Good
Yes,
morning.
Mr. Clayton.
This morning, I appeared together with Mr. Ram Logan and Mr. Jamie Burton, and my learned friend Howard Stevens is taking up cudgels for the state. Just a few housekeeping matters. I hope you will have received a supplementary note from us about Section 13. I understand from briefly discussing it with Mr. Stevens that Section 13 doesn't come into this at all, so that was actually one of our submissions. So that fortunately you can put that to one side. That means that most, but if not all of the supplementary bundle is irrelevant. There is also a further supplementary bundle, I'm afraid, and that is there because unfortunately Part 1 of the Trinidad Constitution was not included in its entirety, and at one stage it looked as if it should be. And the other case in there is Gary, where for reasons unknown to me, the Court of Appeal rather than the board's judgment appeared in the bundle. So you have everything there that you should have, I hope. The other matter I should raise is that we were fortunate enough to have Professor Forsyth do some work for us in relation to the comparative jurisprudence, and he regrets that he cannot be here, but nevertheless, obviously his help, we benefited from his insights.
But we are concerned with a very narrow issue, aren't we?
I think it is very narrow, yes. Can I just say what I would, very briefly, and I hope we're on the same page. The case, as my lords and ladies will apprehend, is about the failure to implement legislation to accommodate children in breach of children legislation enacted for that very purpose. It is, as if I may respectfully say so, and as I was going to say, a very narrow issue, really. It is whether someone, in circumstances where there is no appropriate accommodation and where it's unlawful for them to be accommodated other than in a community residence, whether they, an order giving custody, putting them in the custody of the mother, is an appropriate order given the legislative framework. It's also worth saying at least two things. I mean, to some degree, well, not to some degree, the Court of Appeal treated this issue as an issue of principle, principally, and we would emphasize that because there are factual questions which would have followed if the issue of principle had been resolved in favor of the appellant. If there was a possibility of them being put in the custody of their mother, then questions about what would be the appropriate conditions and so forth would obviously have to be considered, and that would be a fact-specific question in our submission. The next thing I want to refer to is that the respondents drew attention to the judgment of Mr. Justice Corcoran on the 24th of May of 2016. Now, that was the judgment in relation both to the appellant Sasha and her younger brother Brian. Brian was 14 years of age when he was arrested for this offence. And it's worth emphasising that that judgment, which was pretty nearly entirely successful from the appellant's point of view of breach of constitutional laws, is itself subject to an appeal. The appeal was heard by the Court of Appeal on the 26th of February 2018, and we await their conclusions. It's also worth saying that in the interim period, and I footnoted this, I'll come back to the reference in a moment, because the children's legislation, if I can describe it compendency, has still not been put into effect, what happened was that the legislature chose to bypass the role of the Children Authority in that process by enacting legislation requiring them no longer to approve the accommodation. And I refer to that at paragraph 39, footnote 70. That's really just for your note. But what essentially happened was that legislation was enacted which withdrew the obligation to have the approval of the Children Authority. But that didn't come into effect until long after the events that we're concerned with today. And the last point I should make is that the respondents say that as of the 8th of December, which is the date of the order concluded for the Court of Appeal, the appellant was detained at St. Jude's. But my lords and ladies will know that two things. One is that there's a substantial amount of evidence that didn't satisfy the requirements of community residence, which I'll come back to. And at that stage, it still didn't address the obligations under the Children Act.
What was the date you gave?
The 8th of December.
Which
Relevance of that.
Year?
Which year?
Oh, so sorry. The 8th of December 2015.
It's 15, because one of the papers, I think, referred to 2017. It should have been 2015.
I'm sure.
Yeah.
I should. I've come to realise at my stage that I seem to suffer from dyslexia. I often transpose numbers.
Well, I think actually it wasn't, so don't confess too soon, because
I don't think it was your
I don't
paper.
think it's you.
Oh, really?
it was Mr. Stevens who's hiding behind his hand at the moment.
Well, it's always.
I expect that was because he couldn't possibly imagine that he would be writing about events that took place in 2015.
Well, that is one of the more remarkable in one sense, but as the board will know from cases from Trinidad, not unique, if I can put it like that. Can I just...
Mr. Clayton, on the 7th or 8th December 2015,
Yeah.
did the Children's Authority accept that the changes made to St. Jude's made this a community residence?
No, that's not our understanding of it.
It didn't?
It did not, no. It just, basically, as I understand the position, and of course there's no evidence one way or the other about this before the board, they just did the best of a bad job. That's our understanding of the position, and there is no evidence.
Is it right that your client got damages for being detained, for being remanded, only up to December 15, rather than up to the date of her 18th birthday?
I think that is right. I think that's right. But what that would require, it's a very long judgment, and what I haven't done is analysed.
Could somebody behind you find the reference in Kokaram J's judgment
Sure.
to the period for which he was giving damages?
Certainly.
My Lord, can I answer the question now?
Thank
I
you.
think it was 8th December 2015.
In Volume 2 of the Bundle of Authorities, tab 17, you've got his judgment.
Yes.
If you could turn to electronic page 1263. He found, I'm sorry, see a heading in the claim of SS, that's the appellant. He found, if you cast your eye down, and made a declaration to this effect, to paragraph 4, against the third defendant, a declaration that the detention of the claimant from the 29th of July 2015 to December 2015 was in breach of, etc. That, I think, is the nearest one gets, because when he comes to award damages, which he does at 1268, para 319, he's not specific as to the period, but inferentially, there was nothing, no period after December 2015 that was in question. And my Lord, just so that it's clear, what your Lordship no doubt was alluding to when you asked Mr. Clayton that question was what I have set out in my printed case.
Yes.
There is that evidence. Apart from that, those are my instructions from the Attorney General.
That it was approved as a community residence?
Exactly as set out are my instructions. That's all I can say.
My lords, I mean...
Whether it was, my Lord, whether it was approved as a community residence or
It's not quite what you said, is it?
it's not. Forgive me, I didn't have it in front of me when I said that. What I have said is my instructions. It was with the approval of the Children's Authority. That doesn't necessarily mean that they approved it as a children's a community, forgive me, residence, I accept.
And obviously it follows from that. The point I was making earlier, which they were making the best of the situation, is that that's all it takes us, as far as it takes us. But fortunately, I don't think a great deal turns on that. I wonder if I could briefly go through the facts of this, because given the nature of the order made, it's of some relevance, although I appreciate you will have obviously read it. 2 points to make is that the evidence, unusually for a case before the board, is directly relevant to the order made and some of the criticisms made of the order made. And secondly, we accept that the trigger date is the 18th of May 2015, which is the date when the children legislation comes into force. And if I could pick it up really from our printed case at page 6.
Sorry, which page?
Page 6. Oh, I'm sorry. What I haven't done is I don't have the references here to the
Well, if you give the paragraph number.
it's paragraph 18.
That's electronic bundle 728.
Thank you so much. I'm sorry. Just picking it up from there, my lords will see that as a result of being placed in adult detention, the appellant had no choice but to mix with adult inmates, although she tried to avoid it, and they encouraged her to smuggle drugs and cell phones into the prison via her body, which they referred to as vaulting, and they also regularly told her stories about the crimes they committed. Next paragraph, they wished to have sex with her, and her instances of adult inmates sitting next to her making sexual advances. That's set out in some detail.
Mr. Clayton, would it not be better to see what Kokoram J said about all this, what findings were made, rather than simple assertions on instruction?
Well, save that. The reason I'm going through it this way is this was the material that was before the Court of Appeal. And whilst the reason why I'm challenging the approach taken by the Court of Appeal, and it's therefore of some importance. I mean, I'm perfectly happy at a later...
so long as we realise these are assertions.
They're assertions.
They were assertions made, and they were not investigated by the Court of Appeal.
No.
Because this was also interim.
Exactly so.
Very well.
And indeed, I'd make a further point, which I'll come to develop later, which is that's precisely the function of a court when it's dealing with interim relief. There's then reference at paragraph 20 to an assault, a reference on the 1st of July to a strip search, reference at paragraph 23 to a threat to kill her, a complaint on paragraph 24 about move to being to the main adult prison. She was 10 feet away from adult prisoners. She could see them. They sometimes talked with her. There was no running water or a toilet. Her cell was very frightening compared to a juvenile. She describes in detail, which I won't trouble my lords with the detail, with communications with adult prisoners, including being asked to have sex. During the first 2 weeks in that division, she went to school, not thereafter. She remained in a cell under a lockdown. She was sometimes allowed to play, and she says she missed her family. That's paragraph 26. Paragraph 27 was that before court describes the position before court hearings and her fears concerning that. Paragraph 29 refers to the 10th of December when she was separated from adult prisoners. She was only allowed out of a cell to use the bathroom twice a day, infrequently allowed out of the cell, and depended on who was looking after her effectively. At paragraph 30, she was informed she was unable to resume schooling because this would result in interaction with adult female prisoners. And then the next evidence, which is perhaps of particular importance, is the evidence given by Miss Mendoza Mason, who's the family law practitioner appointed by the court to effectively advise on the welfare of the minor. And she says, beginning the evidence at 31, there was no understanding of flexibility in the prison relating to the appellant's lack of maturity and ability to cope. In our submission, that's quite important in relation to a minor. No counselling programs were offered, and the prison officers did not hesitate to remind the appellant that she was charged with murder. The usual response to good morning or good evening, what's so good about the morning, I'm going, but you're going to remain here, which affected the appellant as provoking. She reports that the appellant was with adult prisoners until the 10th of September of 2015. And then at paragraph 32 of the case, she refers to 2 female prisoners ordering the appellant to strip naked. She points out that although the appellant was in good health, no access to general medical checkup or dental checkups. She describes what she quotes as the horrible experiences of the appellant intermingling with adult female prisoners, and records being approached by a particular adult prisoner for sexual favors, no special allowances for children at Christmas, and she would have liked more interaction with females closer to her age. So in our respectful submission, it's not a satisfactory state of affairs. And
Well, we can take it for absolute granted that the situation of an underage young person, male or
Yes.
female, placed in an adult prison contains all sorts of risks and dangers and humiliations and failure to adjust to the special circumstances and needs of a child. We can take that for granted.
Sure, okay.
How does it help us?
well, I will get to the law pretty quick, but I do want to just make some points on the facts, because those were the facts.
The facts have not been decided, have they?
These are the assertions.
All right.
We are dealing with
they're not-
interim relief.
Yeah, well, what I propose to do, so that we're clear about this, is the most valuable case in this field is actually a Canadian case, which is the Canadian Supreme Court has a great deal of experience at charter litigation and interim relief.
You don't need to tell us that.
Well, that bit I'm sure I don't need to tell you. But that case makes it perfectly clear that applying American cyanamide principles, that one goes through this American cyanamide process. It expresses particularly strong views about the importance of the status quo, which it rejects as a principle in constitutional cases. It's in our submission, it's the most immediately valuable case. And I will take it to, I promise I won't take very long.
Well, that sounds very interesting, Mr. Clayton.
But the reason why if I can just complete, within 5 minutes, I'm confident I can achieve that, the points I want to make about the respondent, which are really very short. But the evidence that was before the Court of Appeal, and ultimately that is the appeal that my lords and ladies are invited to consider, was really very slight. And as I point out at paragraph 33, the affidavits filed by the defendant were not lengthy or substantial and did not seek to refute the specifics of the appellant's account. That's important. That was the material before the judge. I described the evidence of 34 of Stumain de Graaf, of 35 of Nicole Hernandez, and this is important. The respondent, paragraph 36, did not adduce any evidence in relation to the state's ability to provide a suitable community residence approved by the Children Authority. And then we have the evidence from the Children Authority, which makes it patently clear, and you can read it for yourself, paragraph 37, that is, this wasn't a case where St. Jude failed by a narrow margin to meet the criteria. It failed by a very substantial margin. So that was all the material before the Court of Appeal. Now, if I can just take you through some of the statutory material.
Would you be able to humour me and put into, say, a couple of sentences
Yes.
what the error of principle that the Court of Appeal made, you say, just in a couple of sentences,
Yeah, well,
rather than problems with its application to these facts?
Yeah, right. Well, I say there are several different errors. The first is...
rather than taking you into your submissions, it's the headlines.
Yeah, no, I'll make the headlines if I can, I hope correctly. The first is that the Trinidad Court of Appeal appeared to accede to the submission that everything could be parked until the substantive trial. That is simply wrong in principle. The Canadian Supreme Court is absolutely clear about that. It's an interim application. It's to be considered on American cyanamide principles, and you can't say this all looks jolly difficult, so let's park it and deal with it later.
Don't understand that, really, Mr. Clayton. There ought to have been a community residence from May 15.
Yes.
There wasn't. That's shocking. What the Court of Appeal did was to say that better be one created in the course of the next 20 days, 30 days.
Yeah,
Why do you say everything was parked?
Well,
they looked at the legislation, they realized there ought to be a community residence, they ordered that there should be one created.
But there wasn't.
No, but I'm talking about the order.
Yeah, the reason why they knew, and that's really the importance of the evidence that I was just summarizing very quickly at paragraph 49. There was not the slightest prospect of their producing community residence within that time. that was obvious from the evidence. And that's important. Now, it's obviously a very unfortunate situation for the court to be confronted with a position where there's a legislation enacted, which I'll turn to in a minute, which it hasn't been implemented. But it was worse than not implementing it. There was no prospect on the evidence of it being implemented. And I'll take you through this at the appropriate moment. But what we had was statements from the court saying, really, we really wish you'd get on with it. But I understand that. I don't criticize the courts in any respect for advancing that hope. But there was just no evidence to say it would ever be done. And indeed, it wasn't done. And that's why it's important.
Well, that was principle number one.
That's principle number one.
We're in a very awkward position because Mr. Stevens has reiterated that paragraph 41 of his case represents his instructions, and he says, moreover, though not evidenced in the record, the respondents would respectfully confirm that the order of the Court of Appeal was complied with. Mr. Ram Logan shakes his head and says that's quite wrong. What are we supposed to do?
Well, it's very unfortunate indeed that is said. What I can say is that the hugely long judgment at no stage says, and this is the important point, what is the statutory process in play here? The Children Authority has to approve the community residence as being appropriate. That, in simple terms, was never done. It's as simple as that. They can huff and puff as much as they want about it, but they didn't do that. And that's really important. So what I will demonstrate at the later stage is the only reason the 8th of December came up was because there was a suggestion from senior counsel from the state that the trial would be on the 8th of December. That's the only reference in all this huge amount of paper to how the 8th of December was chosen. It was chosen because it was a hope that there'd be a hearing. That, with respect in Trinidad, is always a problem. And there wasn't a hearing on the 8th of December. There was a hearing on the 24th of May, some 5 months later, 6 months later, actually. So that's the first point. And in our submission, that is of some moment. And I suppose, sorry, I've gone. That's the first important one. The one that's actually, if you turn to page 3, paragraph 5 of our case, I do summarize there the case.
725.
And the case, the first submission is a very, very short one. But basically, that the appellant on the material had a strong prima facie case. The reason I draw attention to that is that effectively what the appellant was seeking was a mandatory order. So to the extent it's a mandatory order, it may be there's a higher threshold test. That's certainly the domestic law in the question. The second point is the submission I tried to express before, which was any question of relating relief must await the final hearing because the law of the land required persons charged with murder not to be placed on bail and should be obeyed. That, with respect, is plainly contrary to principles of various courts. Factor tame, of course, which suspended the law. I'll look at Bukongo in slightly more detail, and certainly the rather important case of R.J.R. MacDonald, which I promise I will turn to. The third concern is that the best interests were not properly considered in the sense that that is a fact-specific issue, and the one best interest consideration which was not taken out was weighing the balance of staying in the prison on the one hand or being remanded into the custody of the mother. That equation was never done. And the fourth
point... Of course, don't forget that the judge at paragraph 70 said, simply put, and this is agreed, it's in the best interests of the minor to comply with the law and place her in a duly approved community residence.
Well, I won't criticize that passage. With respect, I will say that isn't the correct approach. And the reason why I will say it's not a correct approach is that the law, the first thing to say about that is actually the position is neutral, because it was also in the interest of the child to be accommodated in the appropriate accommodation under the Children Act. It's not a factor that points one way, it points two ways. Because here we are with a court and the child being, on the one hand, told as a person on bail for murder, you're not entitled to bail. That's on the one hand. On the other, the Parliament, and due weight has to be given to this, enacted the Children Act in part to give effect to the UN Convention on the Child, which I'll come back to very briefly, and it's plainly unlawful. So it's not there are two sides to the equation, not one. If you say the value of the law of the land is a key factor, then at least weigh in the equation both sides of it, not just one side of it. That's the first point. And the second point about misapply in the best interest is that no fact-specific investigation was done in relation to the true comparators, which were, on the one hand, staying in prison, and the other hand being remanded into the custody of the mother. And then the final point, and I don't shirk from asserting this, I'm afraid, this is subparagraph 4 at paragraph 5, is that the order made basically had no basis on the affidavit evidence, none whatsoever. And so far as I can see, and I've spent a great deal of time trying to run down how the 8th of December got plucked out of the air, and that was because they thought the trial would be that date. What's interesting about that is that might reflect a view about the strength of the case from the Court of Appeal's point of view. That they were hoping there would be a quick trial and that it would be resolved in that way. But that doesn't, in our submission, entitle the court to not acknowledge the impact of the continuing detention of a child in what is unlawful under the Children Act.
Well, quite a lot of that looks like application of principle to facts, but what it does isolate, if that's the end of your list of the errors of principle, is that you'd won on the question of whether effective relief could in principle be granted, notwithstanding Section 22 of the other Act.
Yes.
And notwithstanding the Bansraj case.
Yes.
And so that doesn't come into our deliberations at all.
Well, say this, which is the Bansraj case we adopt with respect all the criticisms made by the Court of Appeal. But Bansraj is a seriously problematic case for interim relief.
But not to the point in this particular appeal.
Well, that's a matter for the board. I accept that. Can I just briefly gather my thoughts? What I wanted to do, if I may, and I am going to take this pretty fast, I think, is refer to the Bail Act, which the reference is EB 794.
Which bit do you want? Let's help you, Mr. Clayton.
Pardon me?
Which bit do you want? Let's help you.
Well,
It's the first schedule.
it's the first schedule.
Page 809.
Yeah, I did want to make one point, however, at this stage. The case is proceeded on the basis that the Bail Act prohibited the order which the appellant sought. And in those circumstances, what the appellant was seeking was a suspension of the Bail Act, and what I would, it is in effect a factor-10 kind of case. That's what I would say it was. However, I have looked through the Bail Act to see if there's any prohibitions in the Bail Act which confine detention to state premises or prison, or which identify the persons who must look after the person in detention, the detainee. Actually, the Bail Act doesn't do either of those things. It's not a point I'm going to spend a lot of time on now, because you can never prove a negative by going through the statute. But if one goes through the statute doesn't actually prohibit someone being remanded or put in the custody of the mother. It's an alternative way of putting it. If I could next turn to the Children Act, and it's worth saying before, just to remind my lords and ladies, paragraph 45 of the case, is that all of this legislation had been enacted some time before. The Children's Act was 2012, the Children's Community Residence and Foster Care Act was 2000, and the Children Authority Act was 2000. If I could begin by looking at the Children Act, which is at 814. The first point to note, and you'll see this is 814, is the Children Act was also enacted under Section 13. So there's no question of the Bail Act having some priority because it's passed by a special majority, because so does the Children Act. That's why the failure to address that point is of some significance when I say the equation, the point about respecting the rule of law really doesn't fly. The next, if you could turn over the page to Section 3, that says a child is under 18 and defines community residence as having a meaning under Section 2 of the Children's Community and Residence Foster Act. So that those are the provisions. And then if we turn through to Section 54, which is 849, Section 54, if you have that, reads, a court on remanding or committing for trial a child who's not released on bail shall order the child to be placed in the custody of the community residence named for the periods remanded. Now, it could hardly be clearer. This is a Section 13 Act passed by special majority, and it's mandatory. It's as simple as that. But it gets worse, if not submission, for this reason. If one turns to Section 60, which you'll find at 857 of the bundle, if you have that, subsection 1 says a court shall not order a child to be detained in adult prison. Again, absolutely unequivocal in tone. It's a shall, no doubt about it. And then subsection 5, where a child is detained in any facility, he should not be allowed to associate with adult prisoners except with the express permission of the court.
I think at one stage there was an issue about whether Section 60, and the side notes of course talks about punishment, whether Section 60, in talking about detention, was talking about remands. Did Cokeram J actually decide that in your favour, Mr. Clayton?
Yes, I'm told he did.
Very well.
Now, the next act I want to turn to is tab 5. It's the Residence Act. It's 899. If you turn to page 902, you'll again see that this is a Section 13 legislation enacted by special majority, so it certainly isn't trumped by the Bail Act. And then the definition sections are contained at 903. A community residence means a children's home or a rehabilitation centre. Children's home is defined at the top of the page, and that a rehabilitation centre is defined at the 3 from the bottom in the interpretation section, so you can see that. Next legislation I want to look at is the Children Authority Act. That's at 945.
Are we to take anything from the Residence Act at this stage, or are you coming back to it later?
Well, no, I don't think I need to. It just defines it. I mean, the essential submission is that what it prescribed wasn't provided.
But is that in dispute?
No, not as far as I'm aware.
It prescribed community residence, it wasn't provided, and you've been paid $300,000 damages for that.
Subject to the appeal.
Subject to the appeal.
Yeah, I mean, that's quite important to realise, because it may end up evaporating into the ether.
Well,
But in other words, the fact that some hard cash passed is no answer to the constitutional claim. And with respect, when one's dealing with minors, it's not an entirely satisfactory basis to resolve the circumstances of this case. Now, the Children's Authority Act is of particular interest for a number of different reasons. If you turn to 948,
Was this also enacted under Section
Yes.
30?
it was, that's the first point. This is another Section 13 case, statute. And then, could I ask you to turn to 950?
So you're saying all the statutes in question have the same constitutional status?
Precisely so. Precisely so. Section 3A, if you have that at 950, the objects of the Act are to promote well-being of all children, to provide care and protection for vulnerable children, and to comply with certain obligations under the UN Convention. So this is an express incorporation of the relevant portions of the Convention. You can then see at Section 4 the establishment of the Children's Authority, at Section 5 its powers.
Is that strictly right? I mean, that it's an express incorporation?
It's no more and no less than the actual words.
That's precisely. They are enacting these provisions in the light of what they see as their obligations under the UNCRC.
Yes. With respect, my Lord Hodge is entirely right. I'm sorry, I was just trying to go too fast. But that obviously is germane to some of the submissions which I'm about to make.
Sure.
Section 5 then sets out the functions, and if I could ask you to turn through to 951, the functions are in 5.1. It's 5.1G, I think, to issue, suspend, and revoke licenses of community residence. That's one of their core functions. And you'll see subsection 2, they have some ancillary obligation to provide services in relation to advice, counselling, and so on. Section 6 is of some significance. It prescribes certain duties. The duty of the authority to promote the well-being of the child, that's obviously important in terms of the licensing process, to act as an advocate, to take all reasonable steps to ensure the availability of accommodation necessary for compliance with this Act, and to take all reasonable steps, this is F, to prevent the child from suffering from ill treatment. And then if we go to 950...
6 ends with except where it's not reasonably practicable.
sorry, that's 6.1. Yeah, well...
That's 6.1G, I think.
Is it? Yes,
Yes.
it may well be.
Yes.
Yeah.
I think the indentation is not entirely clear, but
No,
it
it
only
must be.
refers to 6.1G.
Must be.
Yes, because of the semicolons, yes.
And then we have, if you can turn through now to 954, you can see the authority has a management board, and this is now, actually, and I think I've completed. So what it comes to is that, again, under Section 13, the Children's Authority has an express obligation to satisfy itself about the conditions, whether it meets the conditions for community residence, and importantly in our submission, the reference to complying with certain obligations under the convention, also play a role in how that should be approached. We set out in writing, and I don't propose to develop these further at the case paragraphs 50 onwards, what we think are the relevant matters that arise in relation to the convention. And so that we're clear, well, some of these points are obvious, they don't need to be related. So if I could next go to the proceedings, if I may. If I could ask you to turn to paragraph 55 of the case. We set out at paragraph 55 the breaches of the Constitution which are alleged. It's contrary to be the deprivation of liberty, and we rely on the famous case of Thomas and Baptiste. We rely upon, subparagraph 2 cites the wrong section. It's section 4B, not 4E, forgive me. But that's breach of the equal protection rights, and we rely on the board's discussion of its broad character by Lord Kerr, I believe. And then the complaint that it amounts to cruel and unusual treatment. And it has to be said, and your lordships will have this in mind, I know, that there wasn't a lot said against the fact that this gave rise to it was a strong case of constitutional breaches. What I next want to go to, if I may, is the record, is the Court of Appeal judgments. That's 650. And it's a judgment of Justice of the Appeal Jamadar. If you go to 652.
Sorry, what was the page reference again, please?
652.
652, thank you.
Basically, at paragraph 3 says the trial judge's summary of the background facts is impeccable. At paragraph 4, it identifies the relief. Turn to page 654, please, if you would. It then identifies the issues at paragraph 8, whether the Children Act is applicable, and if there's an arguable case, whether they could grant a conservatory order. Now, in that, the approach of the learned judge was very concerned with Bansiraj, but if the board doesn't wish to view that today, then I won't say anything more about that. But paragraph 9 is quite important. The trial judge resolved the first issue affirmatively. There is a prima facie case. The respondent accepts this finding and agrees further that as long as a child is a minor and not entitled to bail, she ought to be detained on remand in the custody of a community residence. Well, actually, it's not ought to be. It's what the law requires. That's what the law says. That's what the statute says. And then what we have is paragraph 10 is the issues as the judge describes them. Issue 1 about Bansiraj is dealt with at paragraphs 12 to 28 for your lordship's reference 656 to 663. Issue 2 is dealt with at paragraphs 29 to 57, which is 663 to 673. The section 14 point is dealt with at 58 to 68, that's 673 to 678. And the most appropriate order, which is the bit which I expressed concerns about, appears from paragraph 69 onwards at 678. And I'd invite you to turn to 678, please. The most appropriate order, if you have that. Paragraph 69 concludes by saying the failure to place the minor in the custody of a community residence is prima facie illegal, unlawful, and unconstitutional. Well, with respect, I think it's rather stronger than that. It's plain. In these circumstances, what would be in the best interest of the minor? Put simply, it's in the best interest of the minor to comply with the law and place her in a duly approved residence. Well, that rather tells against the point raised by me earlier by Lord Wilson, that the compliance with the law requires compliance with the Bail Act. In reality, this is a neutral position, saying that the welfare of the child is an important factor in the whole exercise. And then the somewhat sophisticated 4-quadrant survey suggests or supports that view. And then it said, despite the coming into force, there are no residents available. Well, that, with respect, has consequences. Then it said, the senior counsel, sorry, what I hope I made this point, but what I should have said and meant to say was that looking at judgment, the Court of Appeal was only concerned with procedural issues. It wasn't concerned with the question of prima facie breach of the Constitution. It was the question of what is the court to do given there was a prima facie case, although I say it should be rather stronger than that. And that the submission is then made, paragraph 71, by Mr. Ram Logan, that effectively, as a result of the position we're in, an order should be made to release the appellant into the custody of her mother. And then said, and this is in our submission is an important and fundamental misunderstanding of principle, paragraph 72, the fundamental flaw in the appellant's argument on this aspect of the case is it has not yet been finally determined that there are breaches of a minor's fundamental rights. These are matters for hearing for the substantive matter. Well, just deal with that, because the second bit I'll criticize separately. That, with respect, is plainly wrong.
Well, 72 seems to suggest that a provision for the interim care of the child somehow predetermines the final order, which it cannot.
That was the second point I was going to, with respect, my lord. So that's why I broke it into two sets. So it can't. So it's defective in two respects. One, it's saying we can park everything, and secondly, it's saying it predetermines the outcome. With respect, if I may say so, as Lord Hodge pointed out, it can't.
Well, yes, but on the ground, if you've allowed your client to go back to her mother, that does have a practical effect for the future, doesn't it?
It does. I accept it has a practical effect, but I accept that. But we're in delicate areas, and of course, yes, in a way, assessing in a child's best interest whether it's better to go home with the possibility of that not remaining the position as opposed to staying where she was, in our submission, the answer is the other answer.
Certainly predetermined is too strong a word.
Yeah.
I think Lord Wilson's point is that it might influence the final outcome, but it certainly wouldn't predetermine it.
No.
Yeah.
And you see, if I can just step back and make a broader point, a further criticism, as it seems to us, of the approach taken by the Court of Appeal is in treating the question as an issue of principle, which is effectively what they did. They didn't go into the particular circumstances of this child, what the impact on this particular child would be, or on the parents. Now, that's quite important from every conceivable perspective. Because although Lord Wilson may be right, even in the generality, that it may have been inappropriate, if I can use that word, for a child to be taken out to the mother and then brought back, that must ultimately depend a bit on the child. And I want to deal with another point, because I think there's a suggestion at some stages by the respondent along these sorts of lines. They say, well, after all, the child is only 17. Well, that, with respect, takes no one anywhere unless you look at the particular level of maturity of the particular individual in question.
Mr. Clayton, you won't have forgotten paragraph 37 of Mr. Stevens's case. You won't have forgotten his reference to an affidavit that Ms. Gemman filed in the brother's proceedings, which raised doubts about the mother's capacity to control.
Well, yes.
Can we look at that affidavit?
Yes, we can.
Can we look at that affidavit?
Yes.
Because all I've found so far is the affidavit of Ms. Gemman in these proceedings rather than in the brother's proceedings.
Well, sorry, the only one I found was in these proceedings.
No, I'm talking about what Mr. Stevens is talking about, an affidavit filed in the brother's proceedings.
Well, it appears to make similar allegations to the ones contained in
It's page 401, paragraph 16 of the affidavit.
Yeah, can we just look at that? Sorry, that's 401. Yeah, it's 401 in the record. I think, can we just...
Specifically, subparagraph D.
Yeah, no, I'll come to that, thank you. Yeah, so...
I mean, can you, at some stage convenient to yourself, can you deal with that?
Yeah,
and say what the evidence, such as it was, in opposition to that, was in the Court of Appeal and before the judge?
Can I just check something, because it's quite important if it's the evidence in the brother's case. Because, as far as I'm aware, there's no reference to it in the judge. It wasn't evidence before the Court of Appeal. That's the first... Is that right?
It's not referred to in the judgment, but it is in the transcript of argument.
Right, okay.
I won't interrupt further at this stage, but it is.
Well, thank you for that. Okay, then that was a bad point.
Well, it's in the record anyway, so it must have been.
Yeah, okay. The second point I want to make is that you can read, if you look at paragraph 16D, you can see what it says.
So what did Mr. Ramlogan do about that?
Right, well, he responded in a substantive matter, but not in the Court of Appeal, apparently. But can I make a point which, in our submission, is of some importance? In our submission, I should make two things. This is, it says what it says, but it's not very specific. And what would, in our submission, have been the sensible course if the court had entertained the possibility of custody to the mother, would then to invite both parties to put whatever evidence before it, or either it or to remit it to the first instance judge, so they would decide whether it was appropriate in the factual circumstances of the particular case. And that's why I differentiate, as I have done, between saying there's an issue of principle, which is essentially what there's no reference to this in the judgment. So what we have actually is an issue of principle resolved by the Court of Appeal. That's not an appropriate order of custody to the mother. And what I would respectfully submit is that had that issue of principle been resolved, it would have been appropriate for a court, whether the Court of Appeal because of time or the first instance judge, to consider the particular circumstances of the case. Because the judgment is actually expressed in very general terms. It's general terms which are said to tell against the order, not the particular circumstances of this child.
So are you accepting that no order that your client be returned to the mother could have been made in the Court of Appeal on the date when the oral decision was announced?
No, because as I say, what should have happened, and you can see this from the tenor of the Court of Appeal's decision, is they dealt with the issues of principle, which, for reasons I've already indicated, they got wrong.
But that's not Lord Wilson's question, with respect.
Well, what I would
When you
suggest...
say what should have happened, could you continue to the end of that sentence?
Yeah, what I would respectfully submit is what should have happened, and particularly in light of Lord Justice of Appeal Jamadar's rather sophisticated approach to special interests, is the particular facts of this case should have been investigated. It merited it. I mean, on the face of it, this is a striking case.
Should have been investigated on an interim basis or at the final
All I'm
hearing?
saying is this, is that the parties should have been given an opportunity to put in evidence to look at how this should play out in relation to this individual appellant, and then the court could take a view. Because it appears to us, at any rate, to be the position that the Court of Appeal took was, in principle, you can't get this order.
In other words, you're saying that prima facie, the Court of Appeal should have recognised that the proper course was to return the child to a parent, but in order to decide the feasibility of it, they would have had to commission or undertake themselves some inquiry into the particular circumstances.
Precisely, which is precisely, my Lord. And that's why I suggested to begin with that really what we have, the way the Court of Appeal approached it was to deal with the issue of principle, and ultimately, had it been persuaded that the principle of the thing could have been achieved, then the question was whether it assisted in this particular case. But rolling up those two issues together, the general and the particular, in our submissions is somewhat unsatisfactory, especially since the reasoning of the court. I mean, it's important in this context to appreciate that the court didn't refer to this evidence at all, and the reason it didn't was because it looked at the issue of principally, and said, no can do.
Well, if the court had concluded that, as I say, prima facie, the child should be returned to her mother, and then either undertook or commissioned an inquiry which established the mother's unsuitability, what would the options?
Well, then I have nothing to complain about, Nothing to complain about. But what, with respect, is quite troubling about the whole approach taken by the Court of Appeal is many of the inquiries that were germane, according to the Court of Appeal, were fact-specific. Yet, no factual investigations were made, and the inference which we draw from that is it's because they dealt with it as an issue of principle, which is, can a child in principle be placed in the custody of the mother? May I just have a moment? Well, the point made by my learned friend, Mr. Burton, with respect is to this effect, which we would submit, is that what they should have done was looked at the evidence that was actually before them and carried out some sort of factual inquiry. And the judgment is not as conspicuous for its failure to give specific reasons particular to the appellant as to why the order wasn't.
Yes, but your nub point is paragraph 72. You say they closed the door on that inquiry as a matter of principle.
Yes.
And you say that is wrong.
Yeah.
And everything else flows from that.
That's, with respect, yes. And indeed, if I may say so, the problem about paragraph 72, which is quite fundamental to how a court should exercise its jurisdiction to grant interim relief in constitutional cases. So I've gone slightly out of my path. Yeah, I think what I'd like to do, if I may, is to take you to the Canadian case, because that does assist us. It's in bundle 4, tab 42. And as the Professor Forsyth says, if I can say this, this remains the leading statement of principle of the Canadian Supreme Court. It's quite old, but that doesn't none the worse for that. It begins at 1933, if you have that. And if I can take you through it, the head note very quickly, the issue in the case was the regulation of tobacco advertisements and health warnings, which was said to breach the right of freedom of expression, an issue familiar to the British courts as well. One of the issues in the case, which I needn't trouble my lords with, was whether there was jurisdiction to grant an injunction, and I won't trouble you with that. Can I take it up from page, this is the judgment of the majority, take it up at page 1954.
And who were the majority?
Forgive me. The majority were, I should know. I know Mr. Justice Sabinka was in the minority. So Sabinka and Corey were in the minority. We find that at page 1940, which is the first judgment. And the others were in the majority, I think the best way of putting it. I'm so sorry, this is a case which certainly many trees have fallen victim to. If we could begin with the analysis. The primary issue to be decided is whether the applicants should be granted the interlocutory relief they seek. And they were seeking interlocutory relief before trial.
Please, can you remind me what page we were on then? Because I can't get the answer to my own question.
It's 1954 on the computer. That?
1954.
Yeah.
Under analysis is what you're...
Yeah. And the primary issue is whether the applicant should be granted the interlocutory relief they seek. Next and then reference is made to the earlier Supreme Court authority, which this effectively supersedes, although discussion is what refers to it. Next paragraph. The applicant asks this court to delay the legal effect of the regulations which has already been enacted and to prevent public authorities from enforcing them. And that's the relief sought is significant and its effect far-reaching. A careful balancing process must be undertaken. On the one hand, the courts must be sensitive to and cautious of making rulings which deprive legislation enacted by elected officials of its effect. On the other hand, the Charter charges the courts with the responsibility for safeguarding fundamental rights. For the courts to insist rigidly that all legislation should be enforced to the letter until the moment it is struck down as unconstitutional might in some instances be to condone the most blatant violations of the Charter rights. Such a practice would undermine the spirit and purpose of the Charter and might encourage a government to unduly prolong final resolution of the dispute. That's a theme I'll come back to, but that's the point that Lord Hodge and I were briefly canvassing. And that, with respect, is plain. They then say, third paragraph, that the jurisdiction for stay and interlocutories are the same in nature. They then talk about the earlier Supreme Court justice case this is on 1955, the following page, a three-stage test. A preliminary assessment must be made of the merits of the case. Secondly, it must be determined whether the applicant would suffer irreparable damage. And finally, assessment which should be made as to which of the parties would suffer greater harm. I should pause here to emphasize, although it's probably obvious, well, it's the next page really, it's 1956. The linchpin of all of this is the American cyanamide principles. That's the strength of the plaintiff's case. Prior to it discusses the position, and then it says at the middle of the first paragraph, the American cyanamide standard is now generally accepted by the Canadian courts. It then discusses instances where there might be a more stringent non-American cyanamide standard. That's the second paragraph, canvassed in the earlier case. And there's some discussion of that. And if I could ask you now to turn through to 1958. They conclude that discussion by saying, this is just the end of the paragraph at the middle of the page, it follows that we're in complete agreement with the conclusion of Justice Beets, in the Metropolitan Stores case, that the American cyanamide serious question formulation is sufficient in a constitutional case where the public interest is to be taken into account in the balance of convenience. What then are the indicators of a serious question to be tried? There are no specific requirements to be met, but the threshold is a low one. The judgment on the application must make a preliminary assessment of the merits of the case, and I'm going to return to that because that's emphasized in the summary. Goes on to say at the bottom of the page, once satisfied the application is neither vexatious nor frivolous, the motions judge, because in Canada it's dealt with by the motions judge, should proceed to consider the second and third tests, even if he's of the opinion the plaintiff is unlikely to succeed at trial. They say a prolonged examination of the merits is neither necessary nor desirable. Then they deal with two exceptions, which I won't burden you with now. But one of them is obviously if it's decisive, like, for example, the case we looked at yesterday. Then I want to go to irreparable harm, which is at 1961. This is really where this is the Canadian formulations, our damage is an adequate remedy. Beets determined the second test, this is 1961, the second test consists in deciding whether the litigant who seeks the interlocutory injunction would, unless the injunction is granted, suffer irreparable harm. Might be suffered by the respondent should relief be granted. It's been considered by some of the courts below Next paragraph, at this stage, the only issue to be decided is whether the refusal to grant relief would be so adversely affect the applicant's own interests that harm could not be remedied if the eventual decision on the merits did not accord with the result of the interlocutory injunctions. Irreparable refers to the nature of the harm suffered rather than its magnitude. So it's an issue about quality, not quantity. That's important. It's harm which either cannot be quantified in monetary terms or cannot be cured. And then it gives instances of that. Now, we would respectfully submit that in this case, dealing with the interests of the minors, that's the territory we're in, that staying in adult prison is damages something for which damages are not an adequate remedy because of the obvious damage to a minor child from remaining in custody. Then if I could ask you to turn through to following page 1963, please. The third test to be applied under D, the balance of convenience and the public interest, you can see this is so similar to the English approach, but it deals with it in the context of a constitutional case, and that's its value. The third test to be applied in an application for interlocutory relief was described by Justice Beats as a determination of which of the two parties will suffer the greater harm from the granting or refusal of interlocutory injunctions. In the light of the relatively low threshold of the first test, draw attention to that. Again, that is a low test. The difficulties in applying the test, many proceedings will be determined at this stage. And then they refer to the famous passage from Lord Diplock in American Cyanamide. And they then refer, the next page, 1964, first complete paragraph. The decision in the Metropolitan Stores makes it clear that in all constitutional cases, the public interest is a special factor. And they then go on to consider how do you approach the question of a constitution and special as a matter of public interest. Picking it up on the same page just above the quote, they refer to an article by Jamie Castles. Whilst Mr. Castles points out, whilst it's the utmost importance to consider the public interest in charter litigation is not unequivocal or asymmetrical, which apparently is a thought emerging from the earlier case. The Attorney General is not the exclusive representative of the monolithic public in charter disputes, nor does the applicant only always represent an individualized claim. Moreover, the applicant, I think can also claim that he represents one vision of the public interest. Similarly, the public interest may not always gravitate in favor of the enforcement of existing legislation. It is, we think, appropriate, say the court, this is 1965, that it be open to both parties in interlocutory charter proceedings to rely upon considerations of the public interest. Each party is entitled to make the court aware of the damages it might suffer prior to a decision of the merits. In addition, either of the applicant or respondents may tip the scales of inconvenience by demonstrating to the court a compelling public interest in granting or the refusal of relief sought. Public interest includes both the concerns of society generally and particular interests of identifiable groups, like we would say minors. We therefore reject an approach which excludes the consideration of any harm not directly suffered by a party to the application. And then, if I could ask you please to turn to 1967. Um, 1967, just under the quote, in our view, the concept of inconvenience should be widely construed in charter cases. In the case of a public authority, the onus of demonstrating irreparable damage to the public interest is less than that of a private applicant, and is partly the function of a public authority, and so on. The test will nearly always be satisfied simply upon proof that the authority is charged with the duty of promoting and protecting the public interest, and upon such an indication that the impugned legislation was undertaken pursuant to their responsibility. Once these minimal requirements have been met, the court should in most cases assume irreparable harm to the public interest would result from the restraint of the action. What's striking about this case, and really very interesting, is that here we're concerned with a conflict between two pieces of legislation, the Children Act and the Bail Act, and both of them have equal constitutional status. And in those circumstances, certainly it can't be said that the public interest tips the balance in favour of the state. Just can't be said that.
Why is there a conflict between those two pieces of legislation?
Well, there may not be a conflict.
No, there isn't, is there, Mr. Clayton?
Well,
the Bail Act says no bail if you're charged with murder,
yeah.
and the Children Act says a child charged with murder should be not bailed but put in a community residence. Where's the conflict?
Well, my lord, with respect, you are right, I am wrong. Occasionally this case has been put rather broadly, but actually the strict position is there is no conflict because all the Children Act does is prescribe the place where a minor should be sent. So, but in a sense, that rather strengthens the point I was trying to make.
I mean, you've got a prohibition against a child being in prison. You've got a requirement of a placement in a licensed residence, which wasn't available, and you've got a prohibition of bail. What does the court do?
Yeah.
That's the issue.
That is, with respect, my lord, yes. But can I just
And you say it's an American cyanamide issue, and in paragraph 72, the court erred in not considering that.
Precisely so. That is the submission. Yeah. But there are other passages here which I would like to take you to. I'm nearly at the end, I'm pleased to say. Could I ask you to look at 1968, the status quo? In the course of discussing the balance of convenience in American cyanamide, Lord Diplock stated, "It is the counsel of prudence to preserve the status quo. This approach would seem to be of limited value in private law cases, and although there may be its exceptions, as a general rule, it has no merit as such in the face of an alleged violation of fundamental rights. One of the functions of the Charter is to provide individuals with a tool to challenge the existing order of things or the status quo. The issues have to be balanced in the manner described in these reasons." In our submission, that is a very pertinent observation and directly applicable to how the Court of Appeal should approach this case. And then the Supreme Court of Canada helpfully then comprised a summary, which I'll just take you through if I may. It may be helpful at this stage to review the factors to be considered on the application for interlocutory relief in a charter case. As indicated in the Metropolitan Stores, the three-part American cyanamide text should be applied. Turning the page to 1969, in the first stage, the applicant for an interlocutory relief in the Charter must demonstrate a serious question to be tried. Whether the test has to be satisfied should be determined by a motions judge on the basis of common sense and an extremely limited review of the case on the merits. The fact that the appellant court has granted leave in the main action might be relevant, but it's not. But neither is necessarily conclusive. A motions court should only go beyond a preliminary investigation of the merits, where the result of the interlocutory motion will in effect amount to a final determination of the action or the constitutionality of the challenged statute. Contrast yesterday with today. At the second stage, irreparable means refers to the nature of the harm rather than its magnitude. That's the middle paragraph. The last third paragraph, third branch, requires an assessment of the balance of inconvenience. Interesting, the phrase of inconvenience, a bit like the risk of injustice, Lord Hoffman in some of the other cases. In addition to the damage each party alleges it will suffer, the interests of the public must be taken into account. The effect of a decision on the application will have on the public interest may be relied upon by either party. The public interest considerations will carry less weight in exemption cases than in suspension cases. And on one view, this is a suspension case if it's a factor term case, if there is a conflict, although with respect, I don't think there is a conflict, and that point has already been forcibly reminded me by Lord Wilson. When the nature and purpose of the legislation is to promote the public interest, a motions court should not be concerned whether the legislation has that effect. It's assumed to do so. In order to overcome the assumed benefit of the public interest, the applicant who relies on the public interest must demonstrate that the suspension of the legislation would itself provide a public benefit. Well, again, this is actually really quite an interesting case in the sense that we actually have legislation pointing both directions of equal constitutional status. And certainly, as a result of that, you can't conclude, as a matter of principle, that one trumps the other. So
Incidentally, Mr. Clayton, this was a judgment of the court. There were no dissents.
Oh, I'm so sorry.
And it was delivered by Sapinka and Corey.
Oh, it's my fault. I apologize. It's
But
just
it had some very powerful people as well on the court. So.
Thank you very much, my lady. I'm afraid one of the features of Canadian cases is that they don't always put the judgments in the order of who's in the majority. And it's easy to get.
There's a single judgment.
It's a single judgment. I'm obliged. That's my fault, for which I bear responsibility. Can I just, I'm not sure it's necessary to turn to it, but my lords might find it of interest to look at the Bakongo case, which is the board's approach to interlocutory injunctions. Would that be helpful? The point I was going to make about Bakongo is the approach is basically the same, but there was a constitutional claim in it which was abandoned. Now that's authorities 1 tab 8, which, if you bear with me, is page.
Well, you've got a long way, Mr. Clayton, already,
Yeah.
with what's been put to you by my Lord Hodge.
Yes.
Paragraph 72 is wrong.
Yes. All right. Well, that's obviously satisfactory.
I mean, I don't know if Makongo helps you, but anymore.
The only point, Congo, I just wanted to suggest that the Congo, in a sense, is less helpful for this reason. Oh, where is it? So sorry.
Tab 18.
Tab 18.
It is in volume 2.
Thank you very much. So I thought it was tab 8.
Oh, anyway, I may be wrong, but...
No, you're right. It's 1277. I'm going to take this pretty quickly, but Bakongo was an environmental case where the appellant sought an injunction prior to the main hearing before the board, and one question which arose was whether the board had jurisdiction to grant an injunction of its own motion, an injunction having previously been refused by the lower courts in Belize. And I needn't take you to any of that. The issue was about the application of environmental information regulations, the Belize version of that. But what I wanted to do was to take you to 1284, just to point out there was a feature of this in the case, which I'm familiar with because I was in it, which is if you look at 11284, what happened was, if you see, there's reference to a 2003 Act. If I could ask you to look to the bottom of the page at D, there was basically a constitutional, effectively what purported to be a constitutional amendment to abolish the right of the board to gainsay the views of the courts in Belize. So there was a constitutional point, at least at the stage of the interim hearing. And if I could ask you to turn through to 1284, so 1285, forgive me, 1285, paragraph 23, you'll see that Mr. Fitzgerald, who was acting then for on behalf of the government, stated that he did not rely on the 2003 Act as a reason why the board should not grant the injunction, though if it thought it right to do so, the government in Belize would obey any order. The possibility of a constitutional issue being raised summarily was raised in Belize, and it wasn't the time to ventilate it in the hearing. The reason why I draw attention to that is, in our submission, the MacDonald case is a slightly better guide because it was actually considering constitutional issues fairly and squarely, whereas in Bakongo it wasn't. But if you go to 1287, you can see paragraph 35, it's an application of the American cyanamide test, and paragraph 36 basically applies the famous passage from Lord Gough in Factortame. So the reason I draw attention to Bakongo is it's a decision of the board, but in our submission, because of the nature of the contest, perhaps less valuable than the thoughts of the Supreme Court of Canada on the very same issue. Now, I'm sorry to take a lot of time on that, but can I just deal with Can I next go to back to the case and invite you to pick it up? I'm afraid sorry, I don't have the printed numbers. It's paragraph 2, paragraph 72. Forgive me of our case. It's page 28 of the case. The approach for which we contend, and which is consistent with the MacDonald principles, we say is important because paragraph 2, it's consistent with the supremacy provision in the Trinidad Constitution, section 2. That's a simple point, but nonetheless important. That is actually really very important. Where there are breaches of the Constitution, it's important to approach it in a way similar to the Canadian Supreme Court. Thirdly, we draw attention to section 14.2 of the Constitution. And I needn't look at it because I've quoted it here. To give such directions as it considers appropriate for the purpose of enforcing or securing the enforcement of any provisions of this chapter for the protection of which the person concerned is entitled is entitled. So the point I want to make about section 14.2 is it's expressed in very, very broad terms. And to the extent, and I may have misunderstood this, to the extent it's said by the respondents that it has no application to an interim injunction, that with respect cannot be right. It's perfectly obvious from the terms of section 14.2 that it can cover interim relief as well. But there's an important point which I do rely on, which comes out of that, which is there is a principle which the board has enumerated a number of occasions, that end of paragraph 73, the court is entitled to fashion a new remedy to give effective relief when constitutional rights have been breached. And that's an important principle. And I derived that from 3 cases. First is Rameloop, which is in the bundle at 1042, but I'm not going to take you to it. Just to remind my lords and ladies of the facts of that case, it was a case about assault by the police. An award of vindicatory damages, including an additional award, was made, it's said, to reflect the sense of outrage, public outrage, the importance of the constitutional rights, and to deter further breaches. So it was a vindicatory damages to vindicate breach of the Constitution. And if you can just pick it up from the first paragraph, paragraph 17, it's a speech of, or rather opinion of Lord Nichols.
Lord Nichols, yes.
Where he refers to effective relief in the respect of, this is the penultimate line, of the state's violation of a constitutional right. That's the principle he derives from section 14. A similar approach, if you turn to paragraph 75, can be distilled from the Gary case at paragraph 75. Now, Gary, the board's decision is in the second supplementary bundle. To remind my lords of it, this was a case, curiously, brought about by the former Prime Minister of Grenada about property that was sold, that seized after the the Grenadian Revolution of 1983. And what was said there was that he should be entitled to compensation. And the point came up as to whether the court could make a mandatory order against the Minister of Finance. That was the issue before the board, whether a mandatory, so it's a kind of M in the Home Office sort of case. And it's a speech of Lord Bingham, opinion of Lord Bingham, and the passage that I underline, again, is there. It's necessary to fashion a new remedy to give effective relief, the court may do so. So what really it comes to is this, is in our submission there is plenty of authority to support the proposition that it's open to the court, including the Court of Appeal in Trinidad, to fashion the appropriate remedy to give effective relief in the circumstances of the case. And that point is also, although features less prominently in the recent Pittman case by Lord Hughes at paragraph 50. I also draw attention, by analogy, if I may, to the approach taken by the domestic courts to section, this is paragraph 77, section 37(1) of the Senior Courts Act, which allows the grant of an interlocutory injunction in all cases in which it appears just and convenient to do so. It's not the same language, but again, it demonstrates that when courts are dealing with injunctive remedies, that the jurisdiction they have is a broad one, and they have to make they have to formulate an approach which reflects effective relief in the context of the case. The two cases which are in the bundle, actually, but I won't take you to, of DeFalco and Hamill, they are both homelessness cases where the Court of Appeal granted mandatory injunctions. But they have certain similarities with this. That's finished with that point, I think. So we simply say, for the McDonald case and all the additional reasons I've just briefly set out, that paragraph 72 of the Court of Appeal judgment is just plain wrong. But we also say that they misapply, this is the case at 79, sorry, at page 30 of the case, paragraph 79, that they misapplied the best interest test. With respect, the Court of Appeal formulated a sophisticated and entirely unimpeachable legal analysis of how one should tackle the best interest test. But the importance of this in this case is they didn't apply that approach to the facts.
Now, which best interest test are we talking about?
Well, perhaps you could, what I rely on, I'm not going to go beyond the way in which the Court of Appeal put it. I mean, if it helps, we can look at the way the Court of Appeal do.
That might be helpful, yes.
Yes, okay. Well, can we...
you mean the four-quadrant analysis?
Yes, I do. Thank you.
I think that's paragraph 61 on page 676, Mr. Clayton.
Thank you very much, my Lord.
Discussion starts at paragraph 58.
Thank you. Yeah, it does start at 58. And at 59, paragraph 59, 675 says, in constitutional proceedings affecting the mind or the best interest of the child must be the primary consideration.
No.
Sorry, that's what it says.
A primary consideration.
Oh, I'm so sorry. A.
That's what I was getting at.
Oh, I see. Okay. I'm not...
Sorry to be so stern, Mr. Clayton, but it's really important to get this right.
I wasn't in any sense meaning either mislead or to denigrate. I'm
No,
afraid
of course you
my,
weren't. No. But
my eyesight isn't all at once was.
there is best interest of the child may be a paramount consideration,
Yes.
as it is in proceedings relating to their future upbringing.
Yep.
best interest of the child may be the primary consideration,
Yep.
which obviously puts it ahead of all other considerations, or it may be a primary consideration, which is the least of those three possibilities, albeit it still makes them very, very important.
Yes.
And that is all I was getting at.
I quite accept that.
So
And
you agree that
I don't challenge,
you don't challenge that statement, that
No, I
it's
don't.
a primary consideration?
I don't.
Because that comes out of the UN Convention on the Rights of the
Yeah.
Child, Article 3. Yes.
The point I make is this, is that the test, having been very carefully discussed by the learned Justice of Appeal, the actual application of the test is not entirely satisfactory, because he doesn't actually test the position by appreciating that the law of the land, this is paragraph 73, the point Lord Wilson took me to earlier, the law of the land pointed two directions. The law of the land was not in favour of the Bail Act. The law of the land was that, if you counted, there were 3 bits of children legislation, which is Section 13, and there 1 bit of Bail Act, which was Section 13. So, if anything, they counteracted one another. So the law of the land was simply a neutral factor in the circumstances of this case. That's the first important point to make. But the second is, he failed, in our submission, to consider, as a primary consideration, the position in terms of where we would end up if an order was made giving custody to the mother. That's the point. So I made a long...
Yeah, well, what you're saying is there are errors in paragraph 72 and 73, and what should have been done, as I understand it, on your submission is an American cyanamide approach and the fashioning of a remedy having regard to the interests of the child as a primary consideration.
Yes.
Yes.
I think I also would go on to say, if I may, that the application of that test would require the court, when it was balancing, to balance the interests of the child in relation to the actual order that was sought, which was custody to the mother. And there's no discussion of that at all. So in our submission, that's a further error.
But also the interests of the state would go into the balance in terms of whether it was secure enough.
Well, yes, but with respect, I entirely accept that point my Lady Black makes, but subject to this rather important caveat, which is that is quintessentially a factual question, and it may depend on the child. And that was certainly not done, and that's the point I make. It may depend on the child.
Well, I don't know if that is an answer, because what Lady Black is saying to you is that there has to be effective custody arrangements, but they should be fashioned having regard to the interests of the child.
I'm sure it's my fault. What I'm seeking to drive at is it's essentially a fact-specific exercise. You apply the principles and you look at the facts.
But, I mean, as we've already established in your submission, paragraph 72 blocked that fact-specific analysis.
Indeed, but if I may express it in this way, one would hope that our hope at least, is when the board come to review the case overall, that one of the points that might attract itself to the board is that one has to have a fact-specific inquiry, or a court that properly applied the relevant principles would have a fact-specific inquiry as to the appropriateness of the order sought in the circumstances of the particular case. It isn't a black and white question, in other words. It's not a binary question. It depends on the circumstances. And that's an additional point I make, but in our submission it's important.
What actual order do you want the board to make?
What actual order? Well, I think this, because so much water's under the bridge, this may be a case where the judgment speaks for itself. I mean, I'm about to come to my final submission, but which I will make in a minute.
Oh, well, if you would like to deal with that question as part of your final submission, that would be fine.
Okay. Because the final.
But don't forget to deal with it.
I shan't forget to deal with it. I promise. What I wanted to do was to look at the fourth complaint, which is in our case at paragraph 80, was about the fact there was no evidence to justify the interim orders. And with respect, there was simply no affidavit evidence to show that anything was going to happen. And what I want to do is take you back to the judgments, because you can see where this idea comes from. Can I ask you to go to 479 in the record, please?
(479).
Yes, please.
And this is what?
This is the trial judge. And he's dealing with the submissions, and they come to this. Paragraph 40, if I can pick it up from there. The position adopted by Mr. Ram Logan was the child should be released forthwith subject to any other conditions the court may wish to impose. That's the point I made to you a moment ago. Is, to my mind, contrary to the laws, how it would amount to the granting of bail. With respect to the undertaking in the alternative that a suitable community residence be established to impose a mandatory injunction on the state to take these steps, the procedure would, as I understand it, would be for the state to prepare an appropriate facility with attendant costs involved with the Children's Authority dealing with the appropriate process. At the hearing on the 2nd of September, the attorney for the state indicated that having spoken to the relevant members of the government and interested ministries, the earliest for such an exercise could be completed was at least 60 days, and this court sought to encourage that down to 45 days. It was at this point that the applicant's attorney decided to forego discussions in that direction and proceed to the application for the conservatory order, which was custody to the mother. And then to take you to the postscript, it seems that the fairest result at this time would be to accept the suggestion offered by the state at the last hearing, of the late date of the hearing, to make every effort to put the community residence in place, and that the time for the same be limited. Counsel for the state has indicated that the earliest the same could be reasonably completed was 60 days, and this court tried to impress upon it the need for a more expedited approach, suggesting 45. For these reasons, the court cannot impose the intended direction suggested to limit it to 45, but would accept a suggestion bearing in mind the continued damage to the applicant. 2 points I want to make about that. The first is, my lords and ladies will have in mind the evidence from the Children's Authority, which indicated St. Jude's wasn't remotely ready to be to satisfy the necessary tests to become appropriate accommodation. It satisfied, I think, about
15 out of 53, I think.
15 out, yeah.
Yeah, thank you very much. So that's the first point. But the second is that what this emanates from, and I don't criticize either the judge or counsel, is doing the best they can, but there's no evidence at all. Indeed, it may be just a hope. And then we can pick the same point that comes up. Can I ask you to go to page 615, because the issue gets addressed in the argument before the Court of Appeal. It's Mrs. Peake, Senior Counsel for the State. They're discussing at page 614 the nature of the order. At the bottom of the page, it's a constitutional motion. Mrs. Peake says it's a mixed claim, and the substantive matter has not proceeded yet. No. Same directions have been given, and the trial will take place. I'm now at 615. How close are we, by the way, to the hearing of the substantive matter? Sorry, my lord. How close in December? We have filed issues. All the affidavits are in. We filed issues yesterday. We have submissions to be filed. The matter would be tried on the 8th of December. The 8th of December, yes. That's where the date of the 8th of December comes from.
Would you just give me the internal page? Because the bundle page has been obliterated
I'm sorry,
in my
it's
copy.
page 80.
80, thank you very much. No need to read it again.
But
So-
she's talking about the trial of this action.
She is.
Yes.
But
Not the murder trial.
no. That, if I may say so, is some distance away. Indeed, you may have heard from yesterday the length of time these things take to try murders. But the point I'm making is that the date, the order which was given, which was to have community resident by the 8th of December, had no evidential foundation for it. And so far as can tell, and I've spent quite a lot of time trying to figure out where that came from, it actually arises out of a suggestion of where when the trial would take place. And at least 2 points come from that. One is that you might think, or it was an inference you could draw, that thinking the issue might go away on the 8th of December might indicate a view by the Court of Appeal on the underlying merits of the constitutional claim. That's one point to make. Because there wasn't a lot against the constitutional claim that could be said at this stage. But the other is that it was unfortunate because the trial was heard many months later. And therefore, with respect, it's in the context of this case, it was, in our submission, unfortunate.
But
that
I'm sorry, I'm confused. If the respondent is right, it actually was put in place by that date, wasn't it?
No. All right, Mr. Ram-Logan will deal with that, because I think the position is nothing, just the position in summary, just to sort of remind you, is it isn't that all the conditions which hadn't been met by the time had then been met.
No.
All that had happened was that that the child authority had said it's okay. I think.
So they did enough to satisfy the child authority that it was okay to put the young girl there.
I'll leave Mr. Ram-Logan to deal with it, but can I simply say this at this point? That, with respect, is a very unsatisfactory resolution of it. Very unsatisfactory indeed.
Why?
Why? Well, it's particularly unsatisfactory since, I mean, maybe Mr. Ram-Logan has a complete answer to all of this, but none of the relevant material is before the board. And what's more, the truth of the position is that an order of the court had been made, and the child authority was doing the best it can, as was the state, to give effect to it. But that's putting the cart before the horse. The point is that the order should reflect effective relief under Section 14. It shouldn't be an order which is made in the hope that something will turn up, and then, goodness me, it does. That is not a satisfactory resolution.
So, Mr. Clayton, is the position that the Court of Appeal on 12 November, hearing an appeal from a refusal to make an interim injunction, thought the whole thing was going to be looked at fully within 4 weeks?
Yeah. Well, they thought that the trial date was the 8th of December.
And you criticize, you appeal against their disposal, even though they thought they were dealing with a situation that was going to be changed when the whole thing was going to be looked at within 4 weeks.
Well, it's obviously a difficult situation, but let me put it in some proper context. Litigation in Trinidad doesn't always proceed quickly. The hearing on the 24th of May was 6 months later, and you are here concerned with a child being kept in custody. So I can't press the point any further than that, but what I do suggest is it does put the cart before the horse, because effective relief in the constitutional claim was not achieved unless one goes through in some detail what actually happened on the 8th of... I mean, it may be that if my lords want to see this, they ought to see the evidence that was filed, which is relevant to this issue for trial.
Did you say the hearing began on the 24th of May?
Yes.
I thought that was the date of delivery of the judgment.
Oh, I'm so sorry. Yes. When was the hearing? Can you just give me a moment?
Well, please.
Yes, that's fine.
Well, Mr. Clayton, don't waste time. Come back to it.
I'll come back to you. I'm so sorry,
But I mean, you've got to give the judge time to prepare a 150-page judgment.
I understand
So
that,
you
sir.
may be exaggerating the delay in
I
the
may-
hearing beyond 8 December.
I may be, but what I nonetheless don't resolve from is this submission, which is that when dealing with a constitutional case, the court, whilst it has to be pragmatic about how to deal with it, should consider what is effective relief rather than simply adopt a suggestion as to the trial date, particularly in Trinidad when trial dates don't tend to take place speedily. That's a matter which everyone there knows, unfortunately. So even quick things aren't as quick as we might think they should be. Well, I'm told also that the trial wasn't actually listed at that time for the 8th of December.
When did it start? That's the question for somebody to come up with an answer to.
Is there anything else? Is there anything else you want me to say? No, I understand that. My lords, unless there's anything else, those are all decisions.
Could I just ask one question? What was the date? How many days did the government think it would take to put in place the necessary arrangements?
Well, they said at the time of the hearing in front of the first instance judge 60 days, and nearly 60 days had elapsed by the time it got to the Court of Appeal. I mean, I can give you the exact dates, but that's the first thing to note. So it's the 7th of September was the 2nd of September was the hearing in front of the judge, and the hearing in front of the Court of Appeal was the 12th of November. So, I mean, that's effectively 60 days. And nothing, the position was unaltered. And that's important in terms of what happens next. And again, just so that we're clear, I'm not criticizing people for acting in bad faith or anything of that kind. It's just that if you look at the scale of the problem, according to the evidence from the Children's Authority, it was pretty difficult to achieve this. And it's also important to achieve this and getting it up to the appropriate standard. And ultimately, what happened was that the law was changed so the Children's Authority no longer needed to prove this kind of accommodation. That was its ultimate resolution. So, you know, where it really ends, unfortunately, is that the legislative scheme in place when this litigation began didn't carry on. And didn't carry on essentially because the state couldn't give effect to it, it would seem. My lords, there are certain matters which I think Mr. Ramlogan will be able to help you with.
Well, but you haven't answered my question yet.
Oh, I'm so sorry.
Which is actually the most important question in the
no, given the circumstances, in our submission, I think a judgment without any particular, assuming, if I may, that I persuade you of anything in this, then I think a simple judgment would be sufficient in this case because of so much water under the bridge. In our submission, what this case...
But we clearly couldn't order that which you wanted the Court of Appeal to order.
No, but you can... It's a judgment is the best, a judgment which reflects and adopts any of the submissions that commend itself.
But you're not asking us to vary the Court of Appeal's order.
Oh, we can't do that now.
So
no, I mean, it's
what are you asking us to do?
well...
Why are we here?
Well, because there are other cases like it. This isn't the only case of interim constitutional relief in Trinidad. It really isn't. And the fact that the Court of Appeal made, in our submission in relation to paragraph 3, a really quite substantial error of principle would entitle the board, I mean, I appreciate that your lordships don't want to look at Bansiraj, although with respect, if I may say so, the shadow of Bansiraj hangs all over the interim constitutional remedies. That's the fundamental problem, but leave that to one side. A judgment which indicated that the Court of Appeal had taken the wrong approach, if indeed we succeed in that, would be all sensibly we could ask for at this stage. But having said that, it's not just asking for a judgment because it will provide guidance in other cases. This is not the only case where interim relief is sought. It's not even, and your ladyship will have seen this from the paragraph, from this case. There are cases which were stayed pending the outcome of this one.
But does that involve allowing or refusing your appeal if we are not overturning the Court of Appeal's order?
Well, we would ask you to allow the appeal on the footing that the Court of Appeal erred in principle. So allowing the appeal reflected only in a judgment.
But appeals are against orders.
Well,
That's a fundamental principle of litigation, that appeals are against orders.
well, I accept that, but here we're concerned with with an interim remedy. It's certainly no fault of ours that it's taken this length of time to find its way to the board. And it is important with respect that in relation to interim remedies, that if the Courts of Appeal's approach is wrong, for that to be rectified. So I appreciate there is a problem.
Well, it cannot be rectified in the sense of it being reversed for the reasons that you've accepted. So it does seem to me that you have to accept that the appeal against the order must be dismissed, but in the opinion of the board, it should be indicated that the approach taken by the Court of Appeal was wrong.
Well, my lords, I accept the force of that. I certainly acknowledge the point my Lady Hale made, that you do appeal against orders, which it's obviously problematic when you have two things which are in conflict, an interim order and the fact that it takes rather a long time for things to happen to get to the board. What I would, however, say, and in our
Why did it take such a long time to get to the board?
Well, the Court
Maybe people can answer that question.
Yeah.
In another way.
No
need to do it publicly.
Yeah, can I leave that to others for the moment? But what I would say is that if the approach is wrong, then in our submission that is relevant to the question of costs.
Oh,
yeah.
so other days.
But beyond that, I mean I can't. I'm not trying to persuade the board of the impossible. I mean, I do see the force of the points made to me. But we would nevertheless at least conclude by saying this: the issues of principle which are thrown up by the Court of Appeal decision are important, and a fortiori in the context of the case. Unless I can assist you any further.
Thank you very much, Mr. Clayton. Mr. Ramlogan?
My lady? Can I just... Yes.
The learned leader hasn't left you much time, Mr. Ramlogan.
I know this, my lady, and I'll move as quickly as possible. My lady, the first thing I'd like to deal with, my lady, the first issue, is with respect to the compliance with the Court of Appeal's order, as alluded to by my learned friend in paragraph 41 of the case for the respondent. Can I firstly take you to the actual order, and if I can firstly take you to page 646. Because what happened in this matter is, we got a fairly quick hearing in the Court of Appeal, and a judgment was given extempore on the same day. The written reasons came a long time after, and there's a little bit of variance. The judgment is at page 645 of the electronic bundle. And it's very short, but it's very important. We are prepared to grant some relief in this matter, which I'll read out shortly. We don't intend to give extensive reasons. The appeal is from the trial judge's refusal to grant interim relief. He seemed prepared to accept the recommendation of the state that he give some time within which to comply to put the act in force. And he cites the postscript. From a reading of his judgment, however, he felt constrained by Bansraj, and I think also by the fact that perhaps it wasn't really pursued by the applicant. And he says, I think the point was accepted insofar as whatever Bansraj might decide, or however binding it is on this court, insofar as the application was made under the judicial review jurisdiction of the court has the power under that jurisdiction to grant interim relief. I pause there. If you read the transcript, you will see that the Court of Appeal, because of the principle in Young and Bristol Airplane, could not wriggle out completely of the Bansraj legal conundrum. they're bound by their own previous decisions. That is why I had to shift lanes and seek interim protection through the Judicial Review Act. And that is why this case is so important on principle, because notwithstanding what was said in the written reasons that came before, the actual ratio decidendi given by the Court of Appeal was that they sought legal sanctuary and refuge in the Judicial Review Act, because there are serious problems in light of Bansraj in giving the relief under Section 14 of the Constitution. The difficulties in this case, as we pointed out by the judge, are that while we think it is agreed that the continued detention of the child in a place other than a community residence is in violation of the Children Act, granting relief that was essentially asked for, that she be released on bail, is also an infringement of the Bail Act. And we accept the admonition that the court really cannot act illegally. But we also say this. We think it is also, of course, offensive to simply say, as the judge seemed to have done, that relief is refused. We think something should be put in place that would have the effect of the state putting things in place to give effect to the provisions of the Act. So the relief, I was refused any form of interim relief. What they were prepared to give is an order that would force the state to put things in place. The actual order that they made, you will see it on page 649. And this is the order. The order is that the third respondent, the state, provide a suitable community residence. It doesn't stop there. The order has a legal character. It is as provided for in the Children's Act and the Children's Community Residences Foster Care Nurseries Act. It is not an order that you can say that the Children's Authority writes a letter and say, well, we're happy with this. You put a new coat of paint and you change 2 sinks, kitchen sinks, and we're all right with it. It's not that kind of order. It was meant to satisfy the law of Trinidad and Tobago. More significantly, they put a time cap. I don't know if they selected the 8th of December because of the trial date. It certainly wasn't made conditional upon that.
So they made would you describe that order as a mandatory injunction?
I would, my lord.
Yes.
I would.
So they completely bypassed the Bansraj problem by your use of the Judicial Review Act.
Indeed, my lord. Indeed.
Yes.
But that still leaves us with a major problem that the Constitution, which is the supreme law of the land, coming on the heels of the judgment of this board in the Ramanup, which coined the vindicatory damages dimension to redress under the Constitution. It was pointed out by the board in that matter that the concept of redress is not the same as relief at common law or equity. The concept of redress for infractions of the Constitution is the widest possible scope and breadth that a court can have, because it is a supreme law and we are dealing with enshrined, protected fundamental rights and freedoms. I then go to my learned friend's paragraph 41, and before I do that, I just want to get a couple points in on the chronology. Justice Seepersad, in his postscript, which my leader, Mr. Clayton, alluded to at page 479, in the postscript, they said it was a toss-up between 45 to 60 days. I wanted 45. The state said only 60 is the barest minimum. We went to the Court of Appeal. 60 days would have elapsed by the time the hearing took place. And then when you go there, you will see that on the 8th of December, that order would have been made. The trial in this matter did not take place. I'm trying to get the exact date, but we have the date of the judgment. The trial would have taken place a couple of months before, maybe 1 or 2, but it wasn't much. It's a 150-page judgment, but the judge expedited delivery of his judgment. The trial would have been not as far back as we'd like to think. But the short point here is, by that time, the order of the Court of Appeal should have been complied with. Because the order is that they do it on or before the 8th of December 2015.
Yeah, but we're not considering whether or not the government complied with that order. We're here to consider the validity of the order.
Yes, indeed, my lord. But the point I make on this is, insofar as the state says that they complied with the order, had they done so, surely it would have been put into evidence before the trial judge. And there is no evidence whatsoever alluded to in the judge in the course of his judgment or anywhere in the record. There is simply no evidence of purported or actual compliance. Absolutely none. And that is why, my lord, that is why perhaps my learned friend is careful in paragraph 41 of the case of the respondent in how he phrases this. And if I may be permitted to read, he says, moreover, though not evidenced in the record, the respondents would respectfully confirm that the order of the Court of Appeal was complied with. This was achieved by separating a building at St. Jude's School for Girls from other parts of the compound, converting the building to provide bedrooms, upstairs, kitchen and recreational and educational facilities, and recruiting personnel. On the 7th of December 2017, the Children's Authority accepted changes made to the building and she was duly transferred. But what did the order of the Court of Appeal say?
But I think 2017 is accepted as a typographic error. It was 2015.
Well, Lord, I wasn't aware that was
That was accepted by Mr. Stevens at the beginning of the hearing.
Well, I beg your pardon, Millie, that's fine. But, my Lord, in any event, the short point is that what was required by the order of the Court of Appeal was a licensed community residence in accordance with the Act. And that clearly was not the case. I hasten to add that insofar as the evidence at the substantive trial went, the permanent secretary had given evidence, and that is not before you because it wasn't part of the proceedings in the interim application. But the point is that was not confirmed in any of the evidence that was put before the judge. The second point I'd like to make is with respect to my lord's query about the facts might have been a dispute, and we were dealing with an interim application. Well, let's focus for a minute on what was not in dispute and what should have been done. What was not in dispute are three important things which are alluded to in our case for the appellant at paragraph 1, and that is they breached section 61 of the Act, which says a child should not be detained in an adult prison. They breached section 60, subsection 5 of the Act, which says there should be no association with adult prisoners, and they breached section 54(1), which says that a child should be kept in a community residence. So what was not in dispute and known to the court was that there were three breaches of the children's legislation. In the face of that, the question arises as a simple matter of pure law that has nothing to do with facts. If those three sections were breached, what are the constitutional implications in terms of the fundamental rights of the minor? And that issue turns not on facts. It is a matter of pure law. That is why I invited both courts below to grant an interim declaration. And you will see Justice Jamada in the Court of Appeal alludes to that is a possibility. What should have happened here is an interim declaration should have been granted, and based on that, they could have granted relief because there was no need for further facts. It was conceded by the state that these three breaches, in fact, occurred.
I thought what you were seeking was as set out in paragraph 4.1 of the Court of Appeal's judgment, Mr. Ramlogan.
What page is it?
It's on 653, paragraph 4 of the judgment.
Well yes, my lord, of course.
And I thought you were asking for a conservatory order that the Attorney General should direct...
I did, my lord. What happened, my lord?
No, forgive me, I've got muddled. Who's the third respondent?
It's the state, the Attorney General.
The Attorney General should undertake that the second respondent, that's the Commissioner of Prisons, forthwith release your client from custody.
That's
I
correct.
didn't realize you were asking for a declaration.
Well, my lord, one means to get to that relief would have been to make the interim declaration. And when the state appeared at the hearing and they agreed that these violations are made out because there is no community residence and she is being kept in an adult prison facility, I invited the court to grant an interim declaration, and then pursuant to that, you can have the consequential relief. Because if the problem was, as identified by my lord, that the issue of a constitutional violation, you cannot determine it now, and it will be prejudging and predetermining the issue, and hence constitutional relief couldn't be granted. If that was the issue, that could have been easily dealt with by admitting these 3 breaches, which were not in dispute by the state. Those were 3 breaches that flowed as a corollary of the failure to have the community residence. And if that was the case, then effective relief could have in fact been granted.
But I think I've misunderstood something then, because I thought it was being argued by the state that the conditions in which she was being kept in the adult prison could be tantamount to a community residence.
Well,
and therefore your assertion that there was a concession of these doesn't fit with that.
That's why I read the Court of Appeal transcript where the court said it was agreed. And my lady, I say this because the law did not require them to say that we think, it's not a question of opinion. What the law required was a community residence that was licensed by the Children's Authority. And it was not in dispute that there was no licensed community residence as contemplated and required by law to which the child could be lawfully detained. And if the state does not have a place at which the child can be detained in accordance with the law, then the question is, how can they detain the child? And that was the issue. Now my lady, I mean, if for example, no women's prison was built in Trinidad, and you had to remand a woman, are we going to say, by way of a permutation, that it's okay to put her in the male prison, notwithstanding the express prohibition against it in the law, and the obvious constitutional implication for the person's fundamental right? I mean, and the answer that has got to be that the burden rests on the state, on the shoulders of the state, to ensure that the detention of a citizen who is presumed innocent, or for sure a minor, that they discharge that burden. And if they can't, by not having a place as required by law, then the right to liberty springs back in place. Now, my lords, my learned leader, Mr. Clayton, mentioned the point with Bansraj. Bansraj has been a chokehold around the neck of constitutional jurisprudence for over 3 decades. It has caused judges, you will see the kind of intellectual contortions and gymnastics they have to undergo to give justice, to grant remedy under the Constitution. It is ironic that I had to switch leads because I was going to lose the appeal because the Court of Appeal is bound by its previous decision, and I had to go under the Judicial Review Act, which is ordinary legislation, to get relief that I can't get under the supreme law of the land, which is the Constitution. It needs only to be stated for the legal illogic to reveal itself. And that is why we have the issue of Bansraj. It should be, and I invite the board to express...
But hasn't Durity effectively overruled Bansraj?
But they can't, that's the problem. I mean, it's a previous decision of the Court of Appeal. They can't
No, Durity was a decision of this board.
Oh, yes. No, well, milady, no, that hasn't come through. I mean, I don't think they've expressly overruled it with respect. And it does need express words from the...
Well, what Lord Nichols said was completely inconsistent with the decision.
Well, perhaps, milady, but if I may, I can show you what the Court of Appeal in this case said, so you will be clear about it.
But your request, as I understand it, is that we should say something about the relationship between Durity and Bansraj.
Indeed, my lord. And can I take you to page 661, my lady?
Yes.
So that you will see what, even in the Court of Appeal, I mean, I was trying to... I think they didn't take too kindly to me inviting to overrule themselves, but at paragraph 24 on page 661, What they did was to distinguish Bansraj into almost oblivion, I hope, but not overrule it because they can't. And at paragraph 24, you will see they say, insofar as Bansraj is a decision of the Court of Appeal, and to that extent, this court cannot act in variance with the ratio of that decision, we state as follows. So I invite the board, I beseech and implore that we overrule Bansraj, my lady. I put two local judgments. There are many. There's no point burdening the board, and I won't take you to them, but you will see the kind of problems and confusions it's created. Maybe I should take you briefly, but the first one is at volume 2.
He's not returned.
But I'll just give you the references, my lord. It's volume 2, page 1324, volume 14, page 2022. And you will see the problems that it has created for judges insofar as that goes. My lords, I end by saying this. If the state could not provide a place to lawfully detain someone, the right to liberty is the unpainted human rights canvas upon which legislative incursions are made. And that unpainted canvas with the absolute right to liberty springs back into place. And if this child could not have been detained in accordance with the law, then her right to liberty, she should have been granted bail. The question of the mother's fitness or unfitness is a subsidiary consideration to that. But the primary right of the minor under the Constitution is a right to liberty, not to be deprived thereof, except by due process of law. And there could not have been any due process of law or protection of the law as envisaged by the Constitution if she was going to be detained in an adult prison facility. I thank you.
That's the way you put it.
Indeed, my lady.
Indeed. Thank you, Mr. Ramlogan. Mr. Stevens.
Could I just ask for that date?
The date of?
The date when Kokoram J began his
Oh,
hearing.
yes, of course you may. Yes.
Mr. Ramlogan.
We have a date, unfortunately, it finished on the 18th of February.
Finished? No, I wanted the date when it began.
I understand that. I'm just...
As you were saying, look, December to May.
Yeah,
Doesn't seem to be quite correct, Mr. Clayton.
Yes, it did, and that's what I had understood. But I'm pressing, can I ask after this? Though during the whole of my friend's submissions, we've been trying to get an answer, but we failed.
Well, perhaps over the short adjournment, we might be able to discover
Thank you.
that.
We will
Yes.
do that.
Thank you.
My lady and my lord, on that point, I'm afraid I can't assist the board, although inquiries are being made. I confess that I had assumed that the hearing started as the Court of Appeal had been told it was going to on the 8th of December, but apparently that was not the case. We're making inquiries, and hopefully we can also provide an answer after the short adjournment.
Thank you.
Can I deal with various miscellaneous points briefly, because they're matters that have arisen at the latter part of the argument. First of all, it's not with respect right to suggest that the Court of Appeal sought sanctuary from Bansraj in the Judicial Review Act. It's quite clear with respect, as my learned friend Mr. Ramlogan has just said, that the Court of Appeal sought to distinguish Bansraj. One sees that really in paragraph 65 and 66 of the judgment of Jamadar, Justice of Appeal Jamadar at page 677. I won't read these paragraphs for present purposes, but could I invite you, having drawn your attention to those paragraphs, just to turn the page to page 678, where at paragraph 68, the Court of Appeal said this: thus, insofar as the judge concluded that he lacked the jurisdiction to make any interim orders other than under Bansraj-type conservatory order, he was plainly wrong. He had the jurisdiction to do so in this case by virtue of Section 8 of the Judicial Review Act and also pursuant to Section 14 of the Constitution. Now, whether in fact it's a power derived directly from Section 14 or it's simply a power which can be deployed where there is a claim which seeks redress under Section 14 is a nice point and doesn't matter much, but the fact of the matter is the Court of Appeal accepted they had the jurisdiction both as a matter of judicial review and also constitutional jurisdiction. As to another point that was made by Mr. Ram Logan, namely the relief that was sought, can I just ask you please to turn to page 653, which is also in the judgment of Justice of Appeal Jamadar. In paragraph 4, he sets out the relief claimed, including the relief that my Lord Wilson put to him. And then in paragraph 5, both before the trial judge and this court, counsel for the appellant insisted that the only appropriate relief that should be granted was the release of the child into the custody of her mother. And that is why the Court of Appeal considered that and did not consider any declaration. The third miscellaneous matter is this, that both parties in their cases, so I share responsibility for this, refer to Section 54 as providing in the present tense and then set out the terms. In fact, however, Section 54 has been amended. It was amended in 2017 by the Family and Children Division Act, and I'm going to show that to you briefly, just so that when writing your judgment, you do not, understandably, as you might have done, recite that it provides in the present tense as follows, because it doesn't any longer. It did then. Could that be handed up, please? You've got it.
Thank you. Apologise for the size of this, but you'll see on internal page, well, it's the fourth internal page, it's actually got a page number of 32 at the top left-hand corner. That under Section 1, this Act may be cited as the Family and Children Division Act 2016. Now, what I think we also have is a legal notice, a proclamation bringing into effect provisions of it. I wonder if that could also just be handed up. Just this one, 38.
So which provision?
What's being handed up now is Legal Notice 38, number 3 of 2017. It's a proclamation by the President, and what it does is recite that it's expedient to bring various provisions of this Act that I've just shown you into operation. And at D, there's a long list, and it includes item 17, you'll see on the third line of D. And then on the next line, J, so it includes item 17J. If I could then go back to the Act and invite you to turn to page 110 at the top left-hand corner, where you find yourself in the 5th schedule, and item 17 appears at the bottom. It provides the Children Act 2012 is amended, and then there are various respects in which it's amended. If you could then please turn to page 116 find little j, so 17j, and you'll see there by repealing section 54 and substituting the following new section, and it is completely different. Section 54.1 provides where a child charged is not released on bail appears before the court and the matter is being adjourned or a hearing or a hearing or trial is pending, the court may, and then there are three options: A, remand the child in custody pending the hearing or trial; B, grant the child bail on such conditions as may be required; or C, release the child into the custody of a parent, guardian, person with responsibility, etc. So, coincidentally, exactly the sort of order that was asked for in this very case. Jumping ahead, well, no, I'll leave that for the moment, my lady. What you will have seen from the proclamation is that the date fixed was the 15th of May 2017. So this is the law as of the 15th of May 2017. My lady, I didn't want you to proceed on a misapprehension that Section 54 still said what it said, because it doesn't, and I'm very sorry that my researchers have only revealed that so late in the day.
But what does custody mean for that purpose?
Oh, well, my lady, I will come to that, if and insofar as I need to. By that I mean I will certainly address it in the context of the relief that was sought by my learned friend. I don't need to answer what it means in this 2017 Act. However, if I were to do so, my submission would be as follows: that custody, in the case of a child, can mean at least two different things. There is the sense well known to the family courts of the care or of the child.
I was actually asking what remand in custody meant.
Yes.
Rather than custody of a parent.
Oh, I see. Well, I was then going to obviously say that custody can, in the criminal context, mean detention. My submission would be that because this refers to release the child into the custody of a parent, it obviously means the former, so into the care or guardianship of a parent. And were we dealing with a case in which somebody charged with murder were seeking release under this new section 54.1c, I suspect that my submission would be, well, that being release into the care of the parent, it is clearly not permissible, see section 5 and the first schedule to the Bail Act. But in the case of someone where there is no prohibition on the grant of bail, it would be one of the three alternatives open to the court. But, my lady, I'm addressing a case which this is obviously not. My primary purpose in showing you this was so that you were aware that there had been an amendment and you weren't going to recite.
No, we're very grateful to you.
I will come back to the form of order sought, which does very much reflect these words, release of the appellant into the custody of her parent, and I will be submitting in due course that that was simply an order which was not open to the Court of Appeal. But can I just stick with the miscellaneous points that I'm seeking to deal with at the outset first? The next point is that paragraph 39 of my learned friend's printed case, to which he has referred, causes, with respect, us considerable concern. It is suggested, and it's page 734, I think, of the electronic bundle. It is suggested, after stating that the appellant remained in adult detention until she turned 18 on the 24th of January 2016, which incidentally we don't accept because of the what I've said in paragraph 41 of my case. It is said after that, however, it is to be noted that even now there are no community residences in existence to accommodate children. I simply don't, with respect, accept that submission, and I fully appreciate that it's not directly relevant for the purposes of this case, but I should not want the board to proceed on that basis. It then says that on the 15th of May 2017, so the very date of the amendment to Section 54 that I've just shown you, new legislation was enacted to amend the Children Act and to bypass, and my learned friend made this submission, the role of the Children Authority. I accept that changes were made, and I'll show them to you in a moment if I may, but I don't accept the implied criticism. 2 years after the Children Act came into effect, the Family Children Division Act 2016 amended the Young Offenders Act to provide that the Minister of National Security can deem a children rehabilitation centre to accommodate a child without reference to the Children Authority. That is partially correct. But, my lady, insofar as this is set out in paragraph 39 and has been repeated in oral argument, I'm bound, I'm afraid, by reference to the self-same act that I've just handed up to address you in relation to that. But before I do that, can I just take you to the evidence in the case? Because it's rather important that the board understands in my submission what exactly the problem was. In other words, what the position in relation to community residences was, both at the time of the litigation below and in the light of paragraph 39 now. Now, at the time of the litigation below, the source of evidence is the affidavit of Christal Gemen, which you have at page 143 of the record. And she, you will see, was the Deputy Director, Care, Legal and Regulatory Services of the Children Authority. She sets out that at the time, it's paragraph 8 on page 149, yes. At the time of proclamation or partial proclamation of the statutes on May the 18th, there were 49 community residences, including 2 which, until that date, had operated as industrial schools under the Children Act of 1925. And those, she goes on to say, were St. Michael's for boys and St. Jude's, where ultimately the appellant was accommodated pursuant to the Court of Appeal's order. I should say that where she says the Children's Authority Act, enacted in 2000 and amended in 2008, envisaged that these industrial schools would become rehabilitation centres, there is a clear error on her part. She should have said the Children's Community Residences, Foster Care and Nurseries Act 2000, because what she goes on to quote by way of a definition comes from that act, not from the Children's Authority Act. She then explains in paragraph 9 that by letter the 26th of January, the Ministry informed the authority that it intended that the 2 industrial schools are to be utilised as temporary rehabilitation centres. And turning the page, she refers to a letter of March the 24th, which the Ministry advised the authority that Cabinet had agreed to the Ministry assuming the interim management of St. Jude's for girls. She then explains the licensing procedure provided for at section 5.3 and sets out the criteria of which the authority have to be satisfied. Then paragraph 12, she says the minimum requirements with respect to rehabilitation centres are more stringent than those for a children's home on account of, and she gives the reasons, but in particular the increased need for security and monitoring at sea, I draw to your attention. Paragraph 14, she refers to the assessment of St. Jude's and then the findings which my Lord Kerr alluded to. And then at 17, in addition to the assessment conducted, St. Jude's was contacted to inquire about the accommodation, and she sets out the response and the reasons why it was unable to accommodate Sasha. And one sees various things: short-staffed, overcrowded, and that it's never provided care for high-risk residents, etc. Paragraph 18, all the existing community residences may be categorised as children's homes, with the exception of St. Jude's School for Girls and St. Michael's. And at the end of that paragraph, the authority is of the view that these homes would not be appropriate for the accommodation of child offenders who would require higher levels of security and monitoring. She then deals with funding, and essentially there's fairly substantial funding of the industrial schools and much less of some only of the other children's homes. And then in paragraph 21, based on the findings, the authority is of the view that there's no suitable community residence. And paragraph 22, need very urgently to identify a suitable rehabilitation centre for accommodating Sasha. Now, just to explain further, I hope uncontroversially, before the relevant provisions of the Children Act and the Children's Community Residences, Foster Homes and Nurseries Act were brought into operation, there were a significant number of private and charitable children's homes, as well as the 2 industrial schools. And upon the bringing into force of the legislation, the Children Act and the other Act, those institutions became community residences. One sees that that happened as a result of the definition, which you've already been shown, in Section 2 of the Children, Community Residences, Foster Homes and Nurseries Act. So that is at tab 4, and the definition that you were shown is at page 903, and you'll see community residence means a children's home or rehabilitation centre and includes industrial schools. And then rehabilitation centre, I won't read that out. So the short point is that where Miss Gemen set out that at the time of proclamation or partial proclamation there were 49 community residences, what she meant was that the existing residences and the 2 industrial schools, as a result of the legislation, became so designated. And that was regardless of licensing. Licensing is a separate procedure under the Act. And if more were needed, if, whilst you've got the Children's Community Residences and Foster Care and Nurseries Act to hand, you would just glance at Section 4, you would see that it there in subsection 1 says, all managers of existing community residences shall within 3 months apply to the authority for a licence. And similarly, section 25 on page 910, where on the coming into force of this Act a community residence is in existence. So it's not, lest there be any misapprehension, the case that there was nowhere which amounted to a community residence. The problem was that there was nowhere suitable to detain, or no community residence suitable in which to detain the appellant. So, with respect, as to the first assertion in paragraph 39 of the appellant's case, it's simply wrong to assert that even now there are no community residences in existence to accommodate children. There were at the time. There just wasn't one that the Children Authority considered suitable to house a child charged with murder, essentially because of the security concerns. As to the position now, which is also the subject of paragraph 39 of the appellant's case, can I just bring matters up to date by telling the board that apart from the existing community residences, there are now 3 dedicated child rehabilitation centres, and you've seen the definition of those, each the subject of designation orders made by the Minister of National Security, one being the Youth Training Centre at Golden Grove, another being St. Jude's School for Girls, and a third comprising land and buildings designated for the purpose of a child rehabilitation centre, also on the Golden Grove estate. Now, my lady, I hesitate to hand up more. Can I just say that we do have the relevant designation orders, and if to complete the picture as to the current position you would like us to hand those up, we can, but perhaps
as long as you share them with...
Of course. Perhaps I could just hand those up without, in fact, taking you through them, just so that you've got them.
Well, is it the position that if these designated residences had been in existence at the time, that the appellant
Could have gone there. Yes.
She could have gone there?
Yes, it is. The problem at the time was that the community residences that were in existence weren't suitable, largely because of the security issues. I won't take you through these, but what you'll see is one is dated the 15th of May 2017, another the 15th of September 2017, and the third the 13th of April 2018. Now, as to the criticism that may be implicit in the assertion in paragraph 39 of the appellant's case that the new legislation that is referred to, which is the very act I've handed up, was enacted to bypass, as it's put, the role of the Children Authority in approving community centres. Can I just take you back to complete this to the Family and Children Division Act, which is the act that I handed you at the outset. And can we go back to Schedule 5? And to internal page 76 in the top left-hand corner. And item 9, which is captioned Young Offenders Detention Act, that act is amended. And then letter B in section 1, which is obviously the section that says what this act is, by deleting the words Young Offenders Detention and substituting the words Child Rehabilitation Centre. So the Young Offenders Detention Act became the Child Rehabilitation Centre Act. If I could then ask you to go to paragraph 9E on page 78, where you'll find what the appellants rely upon for their assertion that the Children Authority has been bypassed. You'll see it refers to repealing section 2 and substituting the following new section. The Minister may, by order, after consultation with the Commissioner of Prisons and the authority, designate premises to be a child rehabilitation centre. That's what's happened in those designation orders that I've just given you. And then, turning the page, subsection 2, premises designated under subsection 1 shall be deemed to be licensed as a rehabilitation centre under the Children's Community Residences, Foster Care and Nurseries Act, and subject to subsection 3, the provisions of that act shall apply. Now, I entirely accept that there is a deeming provision in relation to licensing, But what I would not accept is any suggestion, which may be implicit in paragraph 9, that the involvement of the Children Authority was therefore or thereby sidelined in some way. And as to that, can I take you to the next page, page 80, item 9F, by repealing section 3 and substituting the following sections. 3.1, a rehabilitation centre shall be under the management and control of the Commissioner of Prisons, subject to the powers and functions of the authority under, and then first the Children's Authority Act, in particular section 5.1c and F6 and 22, and the Children's Community Residences, Foster Care and Nurseries Act, and in particular various sections. Then, if I could just take you first to Authority Bundle 1, at tab 8, where you've got the Children Authority Act, at page 943 of the electronic bundle, and invite your attention to section 5 on page 950, which provides, among other things, section 5.1, the authority may have and exercise such powers and functions as are conferred on it by the Act, and in particular may, can I just draw your attention to C, investigate complaints made by any person with respect to any child who's in the care of a community residence, foster home, etc. And then turning the page at F, monitor community residences, foster homes and nurseries, and conduct periodic review, to determine their compliance with such requirements as may be prescribed. And then on the next page, section 6.1, it shall be the duty of the authority, I won't read all of these, but A, to promote the well-being of the child, D, to take all reasonable steps to ensure the availability of accommodation necessary for compliance with this Act, F, take all reasonable steps to prevent children from suffering ill treatment or neglect. Then, my lady, if we could go to tab 5 of the authorities bundle at page 896 of the electronic bundle, where you've got the other Act, the Children Community Residences, Foster Homes and Nurseries Act. And could I just show you 3 sections of that finally? First, section 9 on page 905. It shall be a condition of every residence licence issued under this part. So that's talking about licences issued, and you'll see what it sets out. But also 23 on page 909. Section 23.1, the authority shall make rules for the proper management of all community residences. And finally, section 27.1 on page 911, the authority may authorise one of its officers at any reasonable times to enter any community residences to inspect premises and the arrangements and so on for their welfare and records. My lady, the point I'm seeking to address is this, that insofar as it is submitted in paragraph 39 that there are still no community residences, it is simply wrong. Insofar as it is submitted that the 2017 legislation has sought to bypass the licensing, and it may be, certainly was when I read it, implicit, I thought, bypass the Children Authority, whilst those designation orders which have been made in respect of the 3 new rehabilitation centres are subject to the deemed licensing provision, it is abundantly clear that the authority nevertheless has a multifarious, active, and considerable role in the oversight of such establishments and the welfare of the children who are remanded there. My lady, I'm sorry I've spent so long on paragraph 39, but I didn't want it to give you the wrong impression. There may well have been problems. There were problems at the time this case came before the Court of Appeal. It wasn't somewhere suitable for Sasha, the appellant, to be remanded, and that's why we're here. It's not the case, in my respectful submission, for the reasons that I've just addressed you on at length, that that is still a problem. Can I finally just take you back to the new section 54 at page 116 and show you subsection 2b, where the court, in exercising its discretion under subsection 1, may take into account, b, where the child is to be remanded in custody under subsection 1, hear submissions from the authority as to the community residence best suited to the placement of the child.
Could you have that page again, please?
It's page 116 of the Act that I handed out.
116, thank you.
116, top left hand corner, and it's the new section 54.2, little b at the bottom of the page.
Yes, thank you.
Can I now, before getting into my submissions, which are aimed at making good the state's case that the Court of Appeal can't be faulted for the order it made, just take you back to the judgment of the Court of Appeal, and specifically paragraph 9, and make a submission about what was conceded and what were the live issues when the case came before Cokeram J. Paragraph 9 on page 654 of the electronic bundle, Justice of Appeal Jamadar said this: the trial judge resolved the first issue affirmatively. That's the application of the Children Act. I don't take any issue with that at all. There is a prima facie case, therefore, that the Children Act is applicable to the child's case, and legally she should not be detained in an adult prison. So a prima facie case to that effect. The respondent accepts this finding. So that prima facie case, that is what was accepted, and agrees further that as long as the child is a minor and not entitled to bail, she ought to be detained on remand in the custody of a community residence. Well, that was because, on any view, and the state has never sought to suggest otherwise, that is what Section 54 says, or said, I should say. If I speak in the present tense, can
Well, you can speak of it in the present tense.
May I?
We'll think ourselves back into...
I'm grateful. Can I now take you just to the judgment of Cokeram J, just to show you what was live when the case came before him, which gives some colour to the extent of the concession. You've got it in volume 2 of the authorities, and it's at the first tab, so page 1127. Could you please turn to 1144, where in paragraph 34 at the bottom, Mr. Justice Cokeram said this: this judgment therefore addresses the following issues binding on the parties. A, the definition issue, whether the YTC or the women's prison, the YTC is where the appellant's brother was detained, or the women's prison, fall within the definition of a community residence, or specifically a rehabilitation centre. So that was an issue, and that is because the state, although they lost before the judge, sought to argue that the conditions in which the appellant was detained in the women's prison satisfied the requirements of a community residence. B, the jurisdiction issue. Whether a magistrate in exercising the power under Section 54(1) of the Children's Act and Section 5 of the Bail Act has the jurisdiction, power or authority in law to order that a juvenile who is not released on bail be remanded in the case of the boy at the YTC or in the case of the girl at the women's prison. So that was the jurisdiction of the magistrate. C, the legality issue, whether such decisions of the chief magistrate made on 29th of July 2015, ordering that both of them be remanded respectively to the YTC and the women's prison, is unlawful and illegal. Whether such decision of the Commissioner of Prisons to keep the children at these places of detention was unlawful and illegal. And then D, the constitutional issue, whether the detention of the brother between those dates amounted to a breach, and SS, that's the appellant, from the 29th of January to December the 8th, amounted to a breach of their constitutional rights and freedoms. Now, just pausing there, had there been a complaint about the detention after the 8th of December, one might have expected the judge to have identified a longer period of detention. The next bullet point, whether the failure of the state to provide a licensed community residence upon the coming into force of the Children Act and the Community Residences Act to which these juveniles could be detained pending the hearing and determination of the preliminary inquiry into a criminal offence of which he is accused is in breach of the claimant's rights under sections 4 and 5 of the Constitution. Third bullet point, whether and in what way these provisions of the Constitution are to be interpreted to give life to and recognise the rights of the child in the criminal justice system. And then finally at E, remedies. If there was a breach of the constitutional rights, what is the appropriate remedy? So everything, in short, was in issue before Cokeram J. And that is why I sought to emphasise that what was conceded was that a prima facie case had been made out, see paragraph 9 of the judgment.
I see on remedies, he says, well, declarations, damages, and or the grant of bail.
Yes, he does.
So it was still before the judge that, according to the appellant, there should be a grant of bail.
Yes, and presumably going forward at that point, yes. Yes.
Yes.
Now, sorry, my lady.
Sorry, Mr. Stevens, I put you off your stride.
Well, you did, my lord, but
I do apologise.
I'm not complaining about it. I'm just trying to remember where I was next. Would your lordship bear with me one moment? Well, I'll come back to it.
You had said that everything was at issue before Cokeram J, and therefore the concession was simply that there had been a prima facie case.
Whatever I was going to say did flow from that, but I still can't remember it. But no doubt it will come back to me in due course. Can I therefore move on to something else, and that is the first of the grounds. I see that I've got 5 minutes, and I might just start by dealing with that. The appellant submits in the first ground that the Court of Appeal failed to proceed on the basis that she'd shown a strong prima facie case that her constitutional rights had been breached. Now, my response to that is that in my respectful submission, the Court of Appeal quite clearly recognised that she had a prima facie case and gave sufficient weight to it. And could I take you in that regard to 3 paragraphs of the, well, I only need to take you to 2. The first I was going to take you to was paragraph 9, which we've just looked at in the judgment of the Court of Appeal, but also paragraph 69, if I may. Murder is a non-bailable offence, thus the minor is not in law entitled to be placed on bail, However, the provision of the Children Act, sections 54(1) and 60, clearly provide that in these circumstances the minor is not to be detained in an adult prison and is to be placed in the custody of a community residence as defined by the Children's Community Residences, Foster Care and Nurseries Act. Thus, the failure to place the minor in the custody of a community residence is prima facie illegal, unlawful and unconstitutional. A clearer recognition of the prima facie case it would be hard to find. Additionally, though, one finds an echo of that in paragraph 74. Minor's almost 18 years and so close to being deemed no longer a child. Current incarceration, though clearly prima facie non-compliant with the current law, is and so on. Now, I think I've remembered the other point that I was going to address your lordships on. It wasn't actually linked to the prima facie point, but it was linked to something else altogether, and that's the submission that's been made that there was no evidence before the Court of Appeal to justify the type of order that they fashioned. Can I just take you in that respect to the transcript at page 622 of the record. One finds there, starting at line 39, Justice of Appeal Barrow says, no, for this young lady, a special provision at St Jude's Home for this lady. So that's what the court obviously was considering, some special provision at St Jude's, and that's actually what the state did. Counsel for the state said, well, not only for this child, my lord, the other child on remand.
Any other child?
I beg your pardon?
Any
other child. I'm so sorry, my lord. Others, plural. I know, but in relation to this child, yes, my lord, if we were to make that order, but it is appreciated this impacts on. I saw Justice Cokeram's part of his order asked for information as to the number. I don't know what that number is. Well, then Mrs. Peake says, well, my lord, the boys, the number is large. I think it is 32 at the time, but the girls is just 2. It's just 2, says Justice of Appeal Mendonca, and Mrs. Peake goes on to say, so far as the girls is concerned, it's much easier to solve. In the ensuing exchange, he goes on to make the point that nevertheless there were real problems in doing anything about it. But that was the context in which the Court of Appeal made the order they made. And the other girl, I don't know who she was, it may have been the very girl that the appellant was detained with in the women's prison, I'm not sure. But at any rate, there were only 2 of them. And it was that exactly, an adaptation of St Jude's School for Girls that the state put in place. And paragraph 41 of my case sets out, my learned friend said I chose my words carefully. I did, in the sense that I simply set out carefully what my instructions are. That is what the state did. And as I've indicated, there appears to have been no complaint at all in respect of her detention after the 8th of December, which one gets from the judgment of Cokeram J. And my lady, unlike yesterday, I've kept an eye on the clock, and I think that might, subject to your lordship, your ladyship, be a convenient moment.
It's a very convenient moment, Mr. Stevens. Well, the court will now adjourn, and we'll look forward to hearing from you again at 2 o'clock.